Hey guys, how are you? Not sure that intro worked, but I'm Laura, the real Laura B, and I am so glad to have you here today. We're going to be going over this new motion that Amber Heard has filed in Fairfax for Judge Penny Azcarate. This is not the appeal. Judge Azcarate hasn't gotten rid of her yet. But we are going to take a look at this latest motion on how it applies to being a juror or being a reader of the op-ed. I know there's a lot of legal channels that are covering the specific laws involved. So let's take a look, and I'll be right back. Hi, I'm Laura, also known as the real Laura B from Twitter. I'm a researcher, truth seeker, and a new wave internet journalist. I'm not a lawyer, nor offering any legal advice. Join me on a journey to draw the curtain back to expose key news developments in the world of celebrity lawsuits and current events. Let's get started. Thanks, guys. I am going to try and do some housekeeping here. I understand I can somehow find a way to limit comments to subscribers. And I'm not sure. Let's see if I can find where that is. No luck so far. I've got a couple mods. Hello, everyone. I'm going to get you all a chance to get in here. I am live, and it is definitely not giving me that option. And I want this one. And let's see if I edit audience. Bear with me while you're all getting in the room. Well, I'm seeing it. I've got the chat, and I am not seeing where we limit it. Well, I guess I'm hoping we won't deal with too many bots. Okay. Well, we're going to have to deal with it. Anyway, thank you all for coming. And we've got quite a few people here. That's awesome. Let's get into this. I may have people jumping on and may not. This is a motion that's been filed in Fairfax, not the appeals call. Didn't get a notification. I'm sorry, Linda. Hi from Ireland. Hello, everyone. Super Chats is turned on. If you have a question, because I'm going to be reading, if you type question in front of your question, the word question, my eyes might be able to grab it quickly. Otherwise, I'm jumping back and forth with screens, reading the motion and whatnot. I might have trouble. So let's talk about this motion, and then I will. I've got some new stuff that I don't think anyone shared before, and we'll see how that goes over. Nope, just starting. Okay, so here we have it in Fairfax. Amber Heard's team has filed this. Defendant and counterclaim plaintiff Amber Laura Heard, Miss Heard, respectfully moves this court to set aside the jury's verdict on all three counts of plaintiff, counterclaim defendant John C. Depp, complaint, dismiss the complaint, alternative to order a new trial, and to investigate potential improper juror service. In support, Ms. Heard relies upon the prior record, including objections and arguments during hearings and the trial, motions in limine, motions to strike, and arguments following. I get a kick out of this. Now, at the last hearing when they did the verdict, Judge Azcarate was like, get your objections on, that's it. And Elaine Braderhoff was trying to file a motion, and Penny Azcarate was having nothing to do with this. The judge is like, done. I'm done. This trial's over. Take it to the appeals court. I'm not doing any more hearings, motions, whatever. And Elaine filed the motion. So when she says we respectfully submit, I can just imagine Judge Azcarate's face when he's reading this. Yes, thank you, Suki. Hit the button, guys. Show your support. I really appreciate it. It's a new channel, and I'm still trying to build it. So we have the summary of the argument, and the only thing I'll touch on is the beginning of it. From the beginning, Mr. Depp set out to try this case as a domestic relations dispute. He wished he had tried rather than settled in 2016. Not correct. He settled his divorce, period. That had nothing to do with the DVTRO. The issue began 6 years ago when Ms. Heard obtained a domestic violence temporary restraining order against Mr. Depp on May 27th. That's correct. What she's not mentioning is Ms. Heard later dropped her claim. It never made, once you get the temporary, you have to go to court to get the permanent. That's what Mr. Depp's texts were about. Like, if you do this, I'm going to have to take you to court. I'm going to have to bring the evidence. I'm going to have to humiliate you, annihilate you, do whatever I can to defend myself. So they were going to court. Amber Heard she dismissed her claim. She dropped it. There was no court case. Therefore, there was nothing Mr. Depp could defend against. So no, he never had a chance to make this argument. Thank you, Suzanne. That's very kind of you. Very nice. Thank you. My screen is not working very well, so for me. I hope it's working for you guys. Yeah, it started once JD said he wanted a divorce. Well, yeah, but not the legal claim that he could argue against her DV claims. That's when, I know what you're saying. He wanted a divorce first, and then she filed the DV. Yeah, while out of the country, and he couldn't even defend himself against the ex parte claim. You're right. It was emergency claim. He wouldn't even be there. So I'm going to jump ahead because this is a summary of what we're going to be reading again. So I feel like we're just be reading it in duplicate because it is very long filing. So let's get to the first argument. And what we're going to do in reading this part, two things we can do. She's going to say, hey, the jury got this wrong. They couldn't have come to this conclusion. So we're going to pretend, for those of us who saw the trial, isn't it reasonable what the jury decided? The other thing they're going to argue is nobody could have taken away from the op-ed that was about Johnny Depp or the other specifics. So we're going to have to remember what we felt the first time we read the op-ed, not how it was presented to us on court, but the first time you read the op-ed, what was your takeaway? So that's the two personas we're going to be dealing with today. The jury, okay, the damages awarded by the jury are unsupported by the evidence and the law. Now, we all sat and heard this trial. The whole world did. The jury returned a verdict in the amount of $10 million in compensatory damages and $5 million in punitive damages. The punitive damages amount was reduced to the statutory cap of $350,000. Now, remember, the jury did not know there was a limit on punitive. They gave what they feel like she should have been punished for what she did. And that's what punitive is. These damage awards were unsupported by the evidence presented at trial and cannot be upheld as a matter of law. Where damages awarded are too small or too excessive, courts have the authority to order a new trial on all issues or solely on the issues of damages or the remediator. The remediator is the judge. If the judge said, okay, 10 million is too much, I'm going to lower it to 1 million. So we're talking about the judge. Now keep in mind, just a reminder, she's asking them to throw out the award Johnny got. She wants hers to stand. While a general rule, a trial court should not disturb a jury award that's been fairly rendered and based upon competent evidence, courts have a duty to correct a verdict that plainly appears to be unfair or will result in the miscarriage of justice. So they think that $10 million is way out of range for what they gave Johnny. Circumstances which compel setting aside a jury verdict include a damage award that is so excessive that it shocks the conscience of the court, creating the impression that the jury was influenced by passion, corruption, or prejudice, that the jury has misconceived or misunderstood the facts of the law, or the award is so out of proportion to the injury suffered as to suggest that it is not the product of a fair and impartial decision. Setting aside a verdict is excessive under the conditions in an exercise of inherent discretion. Here, the jury's determination of $10 million in compensatory damages is excessive as it's a matter of law, and there is no evidence to support the verdict. I'm sorry, but I sat through this trial. We all did. We heard Johnny testify. We heard his managers. We heard his financial accountant. We heard his talent agent. We heard even more than one talent. We heard from Carino and we heard from Wiggum. We heard from expert testimony how his career was affected. Mr. Depp was limited to damages from December 18, 2018, that's the date of her op-ed, through November 2nd, 2020, the date the court ruled in the UK that Depp had committed at least 12 acts of DV, including SA, at times causing Ms. Heard to fear for her life. They got to make sure they get in that to the judge. It's not like the judge hasn't heard it. The court, during opening statements in response to Mr. Depp's objection, prohibited Ms. Heard from telling the jury about the Sun article, which was published nearly 8 months before the op-ed and the trial, the outcome of the trial. Well, of course they were prohibited. We've been through this with Elaine. She did the plea and bar. She did another interlocutory appeal to try and get that decision overturned. The judge isn't having it. It's a different court. It's a different country. It's a different legal system. Amber Heard was not a party. She was a witness. She was not compelled to provide evidence. In fact, I'm going to show you how she's cherry-picked evidence against Depp that included evidence that would have helped Depp that she withheld. So Mr. Depp is alleging in this time period, he's limited to this time period in order to keep the UK out. He has to show those damages. The 3-week trial on Mr. Depp's libel claims, this is in the UK, the ensuing publicity surrounding the trial and the UK judgment issued November 2nd. So even though the judgment was issued November 2nd, they're trying to claim that, look, there was a lot of bad press going on after her op-ed through the trial, the verdict, that was released, that could have also damaged him, not just her op-ed. After many of Mr. Depp's witnesses had testified, the court then allowed Ms. Heard to raise, but not admit into evidence the Sun article, the fact of the trial, and the publicity surrounding the trial, but still not judgment. And I said that. They brought it up over and over again. They spoon-fed the jury about this trial that happened. And then I remember they were complaining. Elaine was running around to doing her interview saying, how could the jury not look on the internet? Well, if they had, the first thing they would have looked up is this trial. They would have saw Johnny lost. So that's either they didn't think he had a fair trial or they didn't get on the internet. I'm just checking. The jury instructions. I can't see it. The jury instructions told them how they were to apply, and Judge A told the jury how they didn't have to break it down. Right. Exactly. They had very specific instructions regarding damages, inferred damages, punitive damages, what they believed was, excuse me, they could reasonably conclude from the testimony. Yes, and Amber actually told the jury, go look it up. Go look me up. All right. So it was not allowed to come into evidence. Mr. Depp presented he would not attempt to claim any damages after November 2nd. Notwithstanding Mr. Depp's presentation, he would not attempt to claim any damages other than the period from December 18th through November 2nd. Mr. Depp made no attempt to limit his damages, and his counsel in closing made clear that they were seeking damages from May 27, 2016, the date Ms. Heard sought and obtained the DVTRO, through the present. This was highly prejudicial to Ms. Heard, necessarily created confusion for the jury, and the resulting $10 million compensatory and $5 million punitive damages award reflected the jury's belief it was restoring Mr. Depp's reputation based on Ms. Heard's initial filing of the May 22nd DVTRO, as Mr. Depp's counsel requested in openings and closing. This alone justifies setting aside the verdict and ordering a new trial. No, she made the DVTRO. Yes, that hurt Johnny's reputation. But what happened? Okay, so that was in May of 2017. Does anybody remember what happened in January 2017? Johnny was awarded the People's Choice Award. So yes, the DVTRO harmed his reputation, but not enough so that the public was turning their backs on him. His fans and supporters were not. He won the People's Choice Award. They made no ifs or buts about it. They could have, let's say, finagled the numbers, but he received that award. So it's not fair that the DVTRO permanently damaged his reputation, because it didn't. Were studios starting to back up and get worried? Sure. But he was still getting work. Mr. Depp presented no evidence of any pecuniary damages suffered in the limited time frame as a result of the op-ed. There was no evidence of any projects or lost commercial opportunities because of the op-ed. Well, that's for the jury to decide, right? I mean, we can't know whose studio sit in their office like, God, this would be a great role for Johnny Depp, but we really should pass on it. We can't know that. He did present evidence that they were still talking with Disney, the Disney exec, that Jerry Bruckheimer was still pushing for Johnny right up until the op-ed. They never said anything straight to Johnny until after the op-ed, when the exec announced they're going in a different way. They're going to kick it in the pants and try something new. That's when Johnny found out he was out. He didn't hear from Disney. And they can pour through all these old tabloids, these garbage headlines. But the bottom line, Jerry said he was still trying to push. Jerry Bruckheimer was still trying to push for Johnny right up until the op-ed. Did the UK case harm him? Yeah, sure. He was harmed. But there's harm, and then there's harm, and then there's the last straw harm. And that's for the jury to decide. Whew. Moreover, Mr. Depp cannot demonstrate any reputational damages from the op-ed because the evidence, including Mr. Depp's own testimony, was that Mr. Depp lost nothing less than everything as of May 27th, when Miss Heard obtained her DVTRO against him. And then there were 2 years of just constant worldwide talk about Mr. Depp being the wife beater before the op-ed was even published, including the Sun wife beater article. In addition to reputational damage. In spite of Mr. Depp's representation that he would not seek to introduce or claim any damages, Ms. Heard never agreed that limiting Mr. Depp's damages would obviate the need for the UK decision to be referenced and admitted into trial. So again, backing up, it's what the jury reasonably believed happened to him. Lori Wolf, love you, Laura. Been following you forever on Twitter. I'm glad you started the channel. If you need another mod, I'm happy to help. Yeah, I think that'd be great. Let me get you up there. I know they make me do it from a separate way. That's crazy, but that's what they do. Oh, I have to get through an ad to get to the people.
Stop trouble before it starts with a smart security system.
Okay. So again, it's up to the jury to what's reasonable. Yes, he was harmed here. Okay, Lori, I had you as moderator. Thank you for volunteering. Backing up. So we have the DVTRO. It did not go to court. It was dropped. It was dismissed. They made a public statement. They've gone their way. Johnny won his People's Award. But yeah, sure, it haunted him. It definitely haunted him. We see that when he was in Fantastic Beasts. And the article was written. And even though he went to J.K. Rowling, he says, look, here's the proof. I didn't do this. Please hire me. Keep me working because I did not do this. So yes, it did haunt him, but he was showing I didn't do this. So then they have the UK trial. But remember, the UK trial is not America. It was not televised. It was reported in tabloids like The Sun, who a lot of people here don't read. So a lot of people didn't know about the trial. They honestly didn't here in the States. So how much harm did it cause here in the States? There were headlines about it, of course, some of the salacious stuff that came out. But a lot of people here weren't following the trial. And a big example is that the tapes that were released in the UK trial never made it here. We didn't hear about them here in the US. Drove us crazy. So as they were saying, as far as the op-ed would have been non-existent or at best nominal compared to the Sun article, the lawsuit brought by Mr. Depp, the publicity over Mr. Depp's lawsuit against the Sun in the United Kingdom, the subsequent trial, and the judgment rendered against Mr. Depp. Well, this is going to be interesting because they did bring up the trial in the case. So if this is supposed to be so reputational harming, wouldn't those jurors have heard about this? Well, they went through the voir dire and they said they didn't. And I think that's very indicative to a lot of people in the U.S. They didn't know about this trial that was going on. So it did not harm his reputation as much here in the United States. Moreover, the exclusion of the UK judgment necessarily prevents any reasonable or competent assessment of any damages, including reputational damages, as well as the credibility of Mr. Depp asserting damages. There is no way a jury can determine any level of damage to Mr. Depp from the op-ed without taking into consideration all potential alternative causes of damage, much less such as an overriding one brought on by Mr. Depp's election to file a libel suit in the form of his choosing, claiming irreparable damages to his reputation. There's no damages reasonably tied to the op-ed, much less 10 million, is excessive as a matter of law and should be set aside. That's what the jury was there to decide. I love this one. GRW. I lived in the UK and hardly noticed the trial here. I'm against this on paper, have been for decades. It was all very low key. There you go. If it was low key there, it sure as heck was low key here. Now, as far as these damages, Johnny did present. He had his agent come up and say, Johnny is a very much loved actor, hardworking. People like working with him. They want to hire him. He was working all these movies every year up until this op-ed. And suddenly, he's not working. Now, granted, up until the judgment, he might not have been getting a lot of studio offers. But he had been working, and he proved that. His agents proved that, and then suddenly things dropped off. Johnny claims he lost Disney because of her, and that would have been a $24 million deal, plus whatever the back end could have been. That's why he was asking $50 million. They're saying, no, there's no contract for that, right? Well, let's be reasonable. And I think the jury was reasonable. Could Disney have actually had another Pirates of the Caribbean without Johnny? Without Johnny Depp, without the Captain Jack Sparrow? I think that's a big part of the decision. He may not have had a contract. There may have been options. But the fact is, they weren't making another Pirates right away because they knew they couldn't do it without Johnny. So both sides lost in that one. So they came up with the 10 million. They split it in half. Lori Wolf, he should have gotten more. I agree. I think he should have gotten more too. Taking the evidence in light most favorable to Mr. Depp, there is no evidence upon which the jury could have reasonably relied to determine that Depp suffered any loss because of the op-ed. Again, he had witnesses. She had our expert witnesses coming in with hashtags, right? What was the main hashtag? The biggest one that got the most justice for Johnny Depp. Can you believe that they presented justice for Johnny Depp that had millions and millions of hits, basically telling the jury the world wants Johnny Depp to have justice? While Mr. Depp asserted he lost Pirate 6 because of the op-ed, there is no evidence upon which the jury can rely to reach such a conclusion. Mr. Depp did not have a contract for Pirate 6. There was media coverage that Mr. Depp would not be in Pirates as of October 25th, 2018. That article made me so angry. That article was, they were on a red carpet. There was rumors going around because of the Sun case that could Johnny really be in another Pirates? That was the question. So they asked this guy, I can't remember his name, Beatty, or was the other one? Anyway, he's on the red carpet. He does not work for Disney. He is not an executive at Disney. He was one of the original writers of the first Pirates film, and I don't even think they used his script because his script was the straight up Pirates movie. But he was there at the beginning. They hired Johnny. The scripts got revamped. I think this guy was out. But he was on the red carpet, and the guy asked a question, what do you think if it's true that Johnny is out at Pirates? And he gave his answer. Well, I think he had a great run. I think he'll always be known for this. This article on October 25th had nothing to do with any representative from Disney. It was just some old writer's opinion that he was asked a question. So this was completely out. This was ridiculous. Yes, it was 2 months before the op-ed, but the guy in the article has no role at Disney. Yeah, Annie. Johnny's City of Lies movie and his movie Minamata have lost support from distributors. Absolutely, because of all of this, because of her claims. This all spins around her original claims. Now, granted, they're trying to say they're time barred, but she republicized them in her op-ed. She brought them to mind's mind again. They had given public statements. They had moved in different directions. Depp's agent testified that it was very likely Mr. Depp would not be in the Pirates 6 as of the fall of 2018. And Mr. Depp testified that he would not agree to play a role in Pirates for $300 million and $1 million alpacas. Moreover, the Disney corporate representative testified that Pirates is still a project that's a possibility in development at the studio at present. My ideas, I'm jumping ahead of myself. Number one, yes, the agent said it was not likely, but it was not a no. Jerry Bruckheimer was still working with him. After the op-ed, Johnny was incredibly hurt. He's made this company billions and billions of dollars, not just as an actor, excuse me, but franchise merchandise, his face, his image, everything. He was upset. If they weren't going to use him, why didn't they have the strength, the fortitude to say, hey, we know you've done so much for us, but this is looking really bad with these claims of hers, and now this op-ed, and now this UN ambassadorship, and all her speaking engagements she's going to be doing. We think we're going to have to put this on hold. We're not going to be able to do this. But they didn't do it. They just they put a spokesperson, an executive made a statement and said, yeah, we're moving in a different direction. We're going with Margot Robbie, got these new writers in, and they were finally confirming 3 or 4 days after the op-ed, Johnny was out. Moreover, Disney representative testified that it's still a project and possibly in development because there was such massive outrage on social media. They know they can't do a Pirates of the Caribbean without Johnny Depp. Yeah, they didn't even call him. It was terrible. Thanks, Secret Miss Squirrel. It's nice to see you back. Appreciate you guys modding. It's so nice. Disney's representative further testified that she did not know if Pirates 6 will be ever made. Well, we know that. No Johnny, no Pirates. We already know that. Mr. Wiggins' belief there existed a contract was based on his understanding that Tracy Jacobs, Mr. Depp's earlier agent, had negotiated a deal. However, Tracy Jacobs testified there was no deal negotiated and no commitment from Disney that Mr. Depp would be Pirates 6 while she represented Mr. Depp, which was up until October 2016, 2 years prior. 2 years prior. Tracy Jacobs is a disgruntled ex-agent. Mr. Wiggum, his current agent, believed there was at least an option. And between him and Christian Carino, they were still negotiating and talking with Jerry Bruckheimer, for example. So since the film has never been shot, let alone even written, she doesn't know it's been written. There's a lot of, they've had some writers, they've had some ideas. And it was not November 2nd, the date Mr. Depp's damages are cut off. It would be impossible for Mr. Depp to claim damages for Pirates 6 that Mr. Depp continued to claim it at this trial. And that's what juries are for. They brought the evidence. They made their claims. Amber Heard brought her evidence against it, brought her expert witnesses against this. But the jury reasonably believed that he was financially damaged. So much so that not only did they give him $10 million, but they punished her $5 million for the lies. That was meant to be a punishment. Steve Krause, be careful. Amber's Horde has gone after justice for Johnny Depp's social media accounts. I believe if Elon takes over Twitter, all pro-Johnny tweets may be removed. I don't know. I know I lost my account. Was it right after the trial in the UK? It took me about 30 days to fight to get it back. And they said I was using my platform to spam. Most importantly, there's no evidence that the op-ed has anything to do with whether Mr. Depp will be in Pirates 6. We don't know that. That's up to the jury to decide. The Disney Corp representative testified that no decision maker within Disney has ever said that Disney would not cast Mr. Depp in Pirates 6 or any other Disney project because of Heard's op-ed. Well, of course they're not going to say that. They're going to say things like a certain exec from Warner Brothers said in documents against Amber Heard, there were creative differences. We weren't sure we were going to pick up her option or hire again. We had creative differences. Disney's not going to go on record coming out that they will never hire Johnny again. Look at the great resurgence in popularity he has. This would be a great time for them to hire him again. In fact, while Disney had internal emails commenting on negative publicity relating to Mr. Depp, including the UK trial and judgment, it had nothing in its files referring to the op-ed, much less a copy of the op-ed. And again, that was only based on the person that came to testify, who was supposed to be the person most knowledgeable, who was the person who was saying, I don't know. I don't know if someone's talking to him. I don't know if Jerry broke harmers. I don't know. So she really wasn't the person most knowledgeable. If the jury based any aspect of its award on Pirate 6, this would have been contrary to the evidence, prejudicially impact by Ms. Heard being prevented from introducing the judgment. Well, they never said that he could only claim damages for Pirate 6. In fact, it was defamation per se, which means he didn't really have to show damages at all. The jury could reasonably believe there would be a lot of other employers that would have hired him had it not been for this op-ed, had it not been for this publicity of the op-ed. Because again, this op-ed came with the job of the UN ambassadorship. They're really just throwing random stuff at the wall and see what sticks. Thank you, Catherine. Yeah, this is very typical of Elaine's writing. You know, I have to do something for my client. I'm doing the best I can. Nor is there any evidence Mr. Depp lost any other opportunities because of the op-ed. There's no evidence of any other films being lost because of the op-ed. Mr. Wiggum testified that Mr. Depp did not have any studio films between December 2018 and October 20, but he did not testify that it was the op-ed that caused Mr. Depp to lose the opportunities. Instead, Mr. Carino, Mr. Depp's other agent, testified that the publicity surrounding litigation was harmful to his career. Well, of course it was harmful. Mr. Depp filed the lawsuit against the Sun, and then in June of 2018, and then against Ms. Heard in March of 2018. Mr. Wiggum testified there was a great deal of publicity surrounding the UK trial. Yeah, in the UK, not so much here. And Mr. Depp had not been cast in any film since the UK trial. There was also no evidence of any endorsements Mr. Depp lost or did not receive because of the op-ed. In fact, Mr. Depp still has an endorsement deal with Dior. Yay, Dior. There absolutely no evidence demonstrating the op-ed caused Mr. Depp to suffer any financial losses, and Mr. Depp did not testify to any lost opportunities or financial damages. Again, this is defamation per se, but a jury can assume that her op-ed was so horrible to him that they could believe that people wouldn't want to hire him. In fact, his expert witness specifically said that Hollywood believed her op-ed during the Me Too time, the words in it were basically a call to action in Hollywood: stop hiring Johnny Depp. That's what his expert witness testified. This was a call to action to stop hiring Johnny Depp. That's the evidence right there. Jury compensatory and punitive damage awards were excessive as a matter of law. Well, they might have been excessive for me. I don't make $10 million a year, but Mr. Depp can make $10 million in one movie. Given the jury did not and could not award Mr. Depp damages for any financial or pecuniary losses based on the evidence presented at trial, again, the expert witness said that op-ed was a call to action. The only damages the jury could possibly have awarded to Mr. Depp were reputational damages. And at no point in his testimony or through his experts did Mr. Depp ever claim damages for emotional distress. Reputational damages doesn't have to be tied to it. It could, again, the expert witness said the op-ed was a call to action. Even though reputational damages are not pecuniary, a jury still must award damages that resulted only from the defendant's wrong and not from other causes. That's what the expert said, and that's what the jury decided. Moreover, reputational damages cannot be used to punish a defendant. Well, they didn't use that to punish the defendant. They lost what they believed was the harm to his reputation through her op-ed, as was testified. That is not precisely what happened here. It was compounded by the exclusion of the evidence. That is not what happened. Both sides brought their testimony. The jury came to their conclusion that the op-ed harmed him. I think that was the best evidence, that expert said this was a call to action during the Me Too movement to stop hiring these guys that have accusations and allegations against them. Stop it. Yeah, he did actually claim emotional distress in his original claim. He just didn't lay it out far enough, like the PTSD, et cetera, like she did. That's why he never had to undergo an IME examination. So he did have the general emotional distress. Elaine was in the UK, so I think she's been with her a long time. Yeah, she attended every day of the trial. Didn't he give JD a million toy stuffed animal alpacas? Anyway, Mr. Depp is not entitled to damages for any conduct prior to the op-ed. There's no evidence of damage to Mr. Depp's reputation caused by Ms. Heard's op-ed. Instead, Mr. Depp testified that the damage to his reputation, as when Heard obtained the DVTRO before the op-ed, can't be compensated for. Mr. Depp began his testimony by informing the jury that he brought this case about because 6 years ago, Ms. Heard made some quite heinous and disturbing, brought these certain criminal acts against me that were not based on any species of truth. Mr. Depp then continued his testimony by describing how the accusations from the DVTRO in 2016 spread through the media. The news of this, her accusations, had sort of permeated the industry and then made its way through media, and social media became quite global. Let's say fact, if you will. The more you tell a lie, the more it becomes accepted as a fact. I felt it my responsibility to stand up not only for myself in that instance, but stand up for my children, who at the time were 14 and 16. And so they were in high school, and I thought it was diabolical that my children would have to go to school and have their friends or people in the school approach them with infamous People magazine cover. There it is. The infamous People magazine cover. That's important to remember, because he did bring it up with Miss Heard with a dark bruise on her face. And then it just kept multiplying. It just kept getting bigger and bigger. And she goes on to say, Mr. Depp emphasized that his reputation was damaged before 6 years, well before the op-ed. So it's my responsibility, I felt, to not only attempt to clear my name for the sake of, well, for many reasons, but I wanted to clear my children of this hard thing that they were having to read about their father, which was untrue. It was really taken this full 6 years, and it's been 6 years of trying times. It's very strange when one day you're Cinderella, so to speak, and then in 0.6 seconds you're Quasimodo. Mr. Depp's testimony clearly establishes that the damage to his reputation occurred in May 2016 and was not related to the op-ed. Yes, he had damage, and we showed he won the People's Award. They were moving forward. The people, the audience, the directors, the movie people, the studios were moving forward. He has gotten studios jobs since May 2016. So just because you're harmed doesn't mean you're harmed forever. It doesn't mean you're permanently harmed. You can be harmed and then harmed again and then harmed again. I read mystery books, and I always, these murder mystery books, and I always get a kick out of, they arrest the gal that stabbed the guy in the back. And they find him dead with the stab wound. So she gets arrested for murder. And then after the autopsy, they find out, well, he didn't actually die of the stab wound. Somebody poisoned him. He died from the poison. If it wasn't for the poison, maybe the stab wound would have healed. It wasn't very deep. So you see, even though somebody's harmed you, it's the level of harm that keeps layering on. The main damage came out in 2018 to harm him more. I think it did, because she was the first person. It was her first person account. The Sun was reporting something from the DVTRO that they believed they were able to report. Because she was granted this temporary restraining order in America, the judges must have believed her. That's not what this is about. You're granted a temporary restraining order until you can go to court and prove it. She dropped it. This was not an isolated evidence. Mr. Depp also testified that after the public became aware, the bad news about him was multiplying and multiplying and multiplying throughout media, throughout social media as well, so-called sort of strike media or whatever. And I was taken aback a bit. There were abuse allegations, and then there was alcohol, and then there was drugs and violence. And it was already right then and there before my eyes, spinning out of control. Again, he was under a confidentiality agreement. He could not fight this. And the one time he did try, in the GQ UK article that came out October 2018, she took him to court under arbitration to shut him up. She was denied. Soon after that, allergies. Soon after that is when she wrote the op-ed. She dropped the TRO because she got the penthouses. Actually, she didn't. She wasn't given anything. She dropped the TRO, I believe, because she never wanted to go in court. She wanted money. She got the money. She got her $7 million. She got all her debts paid off. And as Mr. White testified, he also had to get it tax-free. So it had to be grossed up enough for Mr. Depp to pay for all the taxes on the $7 million. So she got damn near $30 million. And there were always people who will still call him an abuser. That's right. He has to live with that the rest of his life. We see that. There are always going to be people that are going to hang on to that UK judgment, or who are going to say the jury was bought off, or They're going to believe whatever's written here. Okay. The allegations were rapidly circling the globe, which is true, telling people I was a drunken, cocaine-fueled menace who beat women. Suddenly, in my 50s, it's over. You know, you're done. This is so true. And it wasn't just with, again, it didn't start and stop with the op-ed, but it got worse after the op-ed. And that's what they testified to. There was lots of negative articles in 2016. True. But I hope that Johnny Depp's team brings up, he won the People's Choice Award after the claim was made. Apparently drunk, whatever. Friends and family seriously concerned about him. Here's why. I call BS. There aren't any friends and family who were seriously concerned that would have given anybody any article the time of day. Clear and epic sense of entitlement, ex-managers say, who I believe lost their lawsuit. I believe that Mr. Depp said Johnny Depp said he was very happy after they settled their lawsuit. Star in Crisis, insane story of his missing millions. Again, you can't fault a guy for taking someone to court. And he did. Reportedly drank heavily and was constantly on the new Pirates movie set. Reportedly. Guess who he was with at the time? Didn't happen beforehand. And goes on and on. Again, financial woes. He sued them. Where did it all go wrong? Yes, he's getting a lot of negative publicity. What's the other reason he gets a lot of negative publicity? Because it's clickbait. And they make a fortune on Johnny's name. And they make a fortune in ad revenue every time people are clicking on their tabloids. And this, again, this isn't stuff that's tried and true in a court. There's no police report. This is just fodder. Rumor fodder. I knew, Shani, I knew the op-ed was about Johnny when it was written. Yeah, there was no, I mean, everybody did. After 6 days of trial, Mr. Depp went back up on the stand and reiterated his testimony to the jury, stating that Ms. Heard's actions on May 27 changed everything. They did. But again, that doesn't mean it ended there. She republicated, when she wrote the op-ed, her claims. And even if she didn't mention them, that's what the jury believed everybody else believed. Now, in the testimony, she also admitted it. Mr. Depp did not rely on his own testimony to claim damages from May 26th. Forward Doug Banya, an expert hired by Depp, was asked to analyze the impact of the allegations of DV made by Heard as it relates to 2016 restraining order, and then asked also to analyze the publication that alleged abuse in her 2018 post-op. Mr. Banya testified that his analysis shows that prior to 2016 and the allegations, the abuse allegations, Mr. Depp was not portrayed in a negative connotation. Then after the 2016 mark, the majority of those results turned into negative things about the abuse allegations. And then even more so after the op-ed, there seemed to be a kind of theme or a flavor of not only abuse allegations, but his drinking and drug use. Even more so after the op-ed. But Mr. Banya admitted that his analysis cannot separate how Mr. Depp's reputation was impacted from the op-ed versus how it was impacted by Heard when she filed for divorce. But that was for the jury to decide, right? We're putting our jury hats. We all heard this. Poor jury Johnny was humiliated at Comic-Con when he took the stage as Grindelwald. The entire room went absolutely silent, shunning him. Sorry, I have to tell you, that's not what I saw that day on TV. I saw people so excited that he was there and cheering him, and he did a magnificent performance. So no, I did not hear absolute silence. I heard a lot of whooping. I heard shot when he came out. They were like, oh my God, is that really him? And then they realized it was him. I saw excitement. Yeah, she had a lot of lawyers that withdrew and left her after those, especially after those tapes came out. Okay, moving forward. Mr. Banya's expert cannot say that Mr. Depp's reputation or public image was affected by the op-ed. That's not what he said. In fact, Mr. Banya testified that Mr. Depp's Q scores, both positive and negative, actually improved after Heard's op-ed, meaning his reputation and public image actually improved after the op-ed into 2020, which again, Mr. Banya admitted into 2020. Well, I think maybe when Mr. Depp filed against her, people saw that as a positive. Finally, we're going to get the truth. Mr. Depp and also the Justice for Johnny came out. Finally, Mr. Depp's counsel improperly emphasized to the jury that it could find damages based on Mrs. Heard Ms. Heard filing for the DVTRO. Counsel began Mr. Depp's closing argument not by discussing the op-ed, but by stating on May 27, 2016, Ms. Heard walked into a courthouse in Los Angeles, California, to get a no-notice ex parte restraining order against Mr. Depp, and in doing so ruined his life by falsely telling the world that she was a survivor of DV at the hands of Mr. Depp. Today, on May 27th, exactly 6 years later, we asked her to give Mr. Depp his life back by telling the world that Mr. Depp is not the abuser Ms. Heard said he is, and hold Ms. Heard accountable for her lies. Counsel for Mr. Depp then went on to tell the jury that Ms. Heard seeking the DVTRO was not based on truth and was instead designed to ruin Mr. Depp. When she walked into the court 6 years ago today, on May 27th, to get a domestic violence restraining order against Mr. Depp, she did so in front of paparazzi, which she called with a mark on her face. The evidence presented at this trial demonstrates that Ms. Heard didn't just want a divorce, she wanted to ruin him. Like Mr. Depp's testimony and the evidence offered throughout the case, there were not isolated remarks, but permeated the entire closing. Again, this is a republication of what she claimed. She also heard the paparazzi shouting, and this is from Linda A., shouting insults after getting the TRO. She really needs to check her hearing. Correct. We've all seen that on YouTube. Those videos, they were not insulting her. They were asking her if she was all right. Did Mr. Depp really hurt her? I mean, they weren't insulting her at all. Like Mr. Depp's testimony, the evidence offered throughout the case, there was no isolated remarks, but permeated the entire closing. That Ms. Heard should be held responsible for seeking the DVTRO. That was 6 years ago this day when Ms. Heard walked into the court. And her publicist, Jody Gottlieb, had tipped off TMZ with an alleged mark on her face, exactly telling the paparazzi, we know that, what side of her face it would be on. You heard from Mr. Depp yesterday that he has been carrying these outlandish, outrageous stories on his back pretty stoically and living with them for 6 years and waiting to be able to bring them truth back. The emphasis of this closing was clear. Mr. Depp was asking the jury to compensate him for the actions that occurred on May 27, 2016, actions to which he has no right to damages. This is improper and calls for the court to set aside the verdict. Not necessarily. She wrote her op-ed saying 2 years ago. Everybody knew what she was referring to. She was referring to when she got her DVTRO, but she was republicating it with her op-ed. Thanks, guys. You're doing great. This is improper and calls for the court to set aside the verdict. The court has a substantial concern that the jury's decision was a result of an attempt by them not merely to compensate, but to punish defendant for remarks about a personal matter in the public airwaves. Moreover, it appears that they intend to punish her for all the negative publicity the plaintiff had received and not just the effects of one interview in March of 2016, which would be the People magazine. She brought it up again. Mr. Depp is not entitled to damages for alternative causes, including the Sun publication, the ensuing litigation brought by Mr. Depp, UK trial, and surrounding publicity of the UK trial. I feel like they're repeating a lot. The evidence demonstrates that any damages caused by Mr. Depp after the op-ed were not caused by the op-ed. There was a number of alternative casualties. The most significant was surrounding the Sun's publication of the UK article in Dan Wooten entitled, How Can JKR Be Genuinely Happy About Casting Wife Beater Johnny Depp in the new Fantastic Beasts film. This was very upsetting, I'm sure, to people who read The Sun, but nobody in the United States is really rarely reading The Sun. And I'm hearing here a lot of UKers don't read The Sun. So was this a lie? Yeah. Maybe this is the only attempt Johnny thought he was ever going to have to clear his name, and so he sued him. But this didn't do massive reputational harm back then, when the article came out. Mr. Depp brought a lawsuit to The Sun on June 13, 2018. That's an important date. That was right before the op-ed. 6 months before, in fact, the op-ed. Because Mr. Depp wanted to clear his name. The exact same quest repeated by Mr. Depp and his counsel throughout this trial. The UK litigation resulted in a 3-week trial in London. Mr. Depp's agent testified there was an enormous amount of press surrounding the trial. Of course there was. In the UK. We didn't hear about it a lot in the US. In fact, Mr. Bain's analysis found that the press surrounding Mr. Depp after Ms. Heard's op-ed did not mention the op-ed, but instead were about Depp's trial in the UK, disturbing alleged text. Other text that was brought out in pre-trial in the UK. Hollywood nervously awaits the fallout of the trial. None of these are dated. Johnny Depp claims this. Okay, this was because of the trial, so this would have been after the op-ed. So moving forward, Mr. Depp cannot, as a matter of law, be compensated for any injuries caused by anything associated with the Sun publication. Well, how can we know that? She just said we can't know what injuries he suffered financially from her op-ed. So how can they now decide, well, he can't be compensated for injuries from the Sun? But you can't know what those, there's nothing concrete. Don't we wish we could, but we can't. And that is up to the jury, right? They sat there, they heard the testimony, they heard the experts, they heard Johnny, they heard Amber, and they came away and said, yeah, we think he lied, and we think he was financially damaged, and we're going to give him $10 million. Yeah. A good attorney, Steve, would look at jury 15 if he, oh, we're going to get to that one. Oh, yeah. They really messed up on that one. Finally, Mr. Depp claimed in his testimony that he had been damaged for the past 6 years, including this through this jury verdict, the UK, including here. Mr. Depp's counsel also argued this in closing. You heard from Mr. Depp yesterday that he's been carrying these outlandish, outrageous stories on his back stoically for the last 6 years. Well, she brought it up again. This completely defied Mr. Depp's representation to the court that Mr. Depp was only going to claim damages for December 18, 2018 through November 2020. Those were the instructions that were given to the jury. Those were their instructions. It is eminently unfair and prejudicial for the jury to be told repeatedly that Mr. Depp was damaged for 6 years up to the present. While Mr. Depp represented the court, he was not claiming such damages. But the op-ed came out of her original claims. And he was moving forward with his career. And I can't reiterate enough. The expert witness that he brought said that op-ed was a call to action in Hollywood because of the Me Too movement. The prejudice is exponentially increased because Ms. Heard was denied the ability to introduce evidence that Mr. Depp's lawsuit against the Sun and Mr. Wooten resulted in an extensive 129-page judicial findings, committing 12 acts, et cetera, an essay. Remember, different country, different laws. She was not a party. They already lost that appeal because they appealed already during the court's time. Oh, the Stanford professor. She's just terrible. I don't know how she still has an account. I don't know how she still has a job. Oh. I got Jax trying to come in. Let me see if I can find her. She's in backstage somewhere. Hopefully she'll come back in. Hopefully Jax will come back in. I had to shrink my screen a little bit so I could keep reading, and I must have made it too small that I didn't see her pop on. And hopefully she'll come back in. There have been several cases that have found damages to be excessive in defamation. Oh, there she is. Hey, Jax. Thank you. I'm sorry. I got my screen shrunk quite a bit so I can file the chat and read the doc at the same time, and I guess I made it too small. How are you?
I'm good. How are you?
Good. Let me, I don't know if you want to adjust. I can adjust your mics. I'm going to adjust your mic up there. I'm learning.
Good for you.
Yeah. So we were talking about, we've gotten through this to about almost halfway.
Yeah.
And basically what they're saying is they cannot separate his damages from the op-ed to the UK trial to the original claim. And for one thing, her op-ed is re-publicizing the original claim. So she's making it new again. I discussed that after she got the DVTRO, Johnny won the People's Choice Award that January.
Yes.
So they were moving forward. Obviously, the UK is a different country, different everything. So we can't count that. But I felt the strongest evidence from one of Johnny's expert witnesses was that he heard in Hollywood the op-ed was a call to action during Me Too. Stop hiring men who have been accused. And that's the strength of the op-ed that I think was the biggest takeaway for the jury.
Yeah, I agree.
So that's pretty much our main key spots here. Now you've gone through this with Brian. So did you make it all the way through? I made it halfway through.
Okay. No, we didn't make
right.
it like anywhere.
So they're trying to say that
we didn't make it like.
You didn't? Okay. So I can't believe she's even coming up with this claim. For example, and this is going to be good for you.
Yeah. Yeah, there's a delay.
Cool. Yeah, I know. I got to get used to those delays.
That's all right.
Okay, so this is going to be right up your alley coming from Hollywood work. For example, Richmond newspapers, they want them to reduce the damage. So this teacher was awarded $900,000 of $1 million compensatory damage award for defamation arising out of the publication of a front-page article in the Richmond Times-Dispatch, which reported on complaints about plaintiff's performance as a teacher. While the court affirmed the judgment that the teacher was defamed, it held that an award of $1 million clearly would have been excessive. And the evidence does not demonstrate the trial court abused its discretion by reducing this award to $100,000. Now, here's my question. Look here. How much do you think a teacher was making in Virginia in 1987?
Yeah, I mean, we're talking about a teacher versus like a massive movie star.
Right. So in 1987, let's say she was making $15,000 a year.
Yeah.
They reduced her award to $100,000. Well, damn, that's like what, 7 times her salary?
It's a lot of money in 1987 for a
teacher.
Do you think
Johnny
it's a lot of money for anybody?
But maybe we should use that same calculation for Johnny. Do you think he would have been happy with 7 times his damages?
Yeah, of course.
So again, using this case to get them to reduce it is ridiculous.
And I just don't think that you compare a teacher to a movie star who regularly makes $25 million per movie.
Right. A movie star of his experience, consecutive years of success, financial success for studios that made money off of him. Yeah. So I don't think $10 million is out of line, and the jury certainly didn't.
No, and he asked for 50. She asked for 100. So
I want 2 times the amount. So again, continue on that. Mr. Depp can point to no damages sustained from the op-ed as opposed to other unrelated events. The $10 million verdict is completely out of proportion with anything even remotely related to the op-ed, especially in light of the Sun article, the lawsuit filed by Mr. Depp, the ensuing trial and admitted negative publicity, and the adverse UK judgment in the same time frame. Ooh. I'm going to skip these court cases. They just feel that the finders of fact, the jury, couldn't possibly have found for $10 million. What do you think of that?
I think that's ridiculous. It's very easy. I'm surprised that they didn't find for more.
So am I. I was really surprised.
He made his case that at least $25 million would have been warranted, in my opinion.
That's what I think.
Yeah.
And I remember a document where it had Pirates 6 on it. And was that maybe an option that was noted somehow?
I'm not sure. I don't think I can recall what document you're talking about, so I'm not sure.
Okay. I wish I could find it again. Not everything was uploaded. Sometimes we could see things that didn't, because the screens were in front of us, that were not necessarily put to the jury.
Yeah, and you know what Jack Wiggum was talking about, first of all, yes, it could very well be an option. But what Jack Wiggum was talking about with that verbal agreement is done every minute of every day at lunch meetings all over town, you know, like, oh yeah, we'll put Johnny in this movie, 25 million. Okay, 25 million. We'll draw it up. I'll send it to you later. Like, yes, right. All the time.
And they argued earlier that, first of all, there's no even guarantee there's going to be a POTC, Pirates of the Caribbean 6. Well, we know why. Right. No pirates, no Johnny. No Johnny,
no Johnny, no pirates.
Right.
Nope.
And the jury could recognize that.
Yeah.
And that's not to say Disney can't finally wake up and go, okay, yeah, I think we should be using Johnny. Look at this popularity.
The other thing is that the jury doesn't have to explain themselves. They don't have to explain why they arrived at whatever conclusion. They could very easily be that they got tired of her shit on the stand and just went, this is ridiculous. She's crazy. He wins. They don't have to explain anything.
Yeah. Yeah. Okay, so it says the same as here, where it appears the jury was punishing Ms. Heard for everything that happened to Mr. Depp from 2016 forward. No. In fact, Mr. Depp's closing asked the jury to clear his name for everything from 2016 forward. No, he asked them to clear his name for this burden he's been carrying, which are the same accusations she made and referenced in her op-ed, right?
Yep.
She republicated it.
Yep.
Instead of asking compensation for proven losses, this is defamation per se, plaintiff's counsel, without objection, asked the jury to require the defendant television station to pay an oh, this is a case. Somehow we got this instead of this case again. Sheckler, yeah. So this is another case. But the jury's $10 million judgment for reputational damages clearly showed that that is what the jury did. They were basically compensating him from 2016 forward. And I disagree. Such an award is excessive and by law should be set aside. Nope. There was no jury instruction on how they should have arrived at that number. Right?
Yeah.
Mr. Depp presented his case. He's experts, his
That's
witnesses, and Amber Heard did the same to oppose him, not just to bring up her $100 million, which she never did. So verdicts on the complaint and counterclaim are inconsistent and therefore should be set aside. This is an interesting argument, and this came up with some of the lawyers. Here, the jury's verdict in favor of Mr. Depp as to his defamation claim and in favor of Ms. Heard as to her claim of defamation are inherently irreconcilably inconsistent and therefore cannot stand. I disagree, and obviously the jury disagree. The verdict found that Mr. Depp did not abuse Ms. Heard at any time. Yes, they did.
Right.
We can say that again. The verdict found that Mr. Depp did not abuse. See, this goes
at any time.
This goes to the Twitter people. They're going, no. They're just saying she can't talk about it.
No, that's bullshit.
This is Elaine Braderhoff saying this. The verdict found that Mr. Depp did not abuse Ms. Heard at any time.
Yep.
Well, at the same time, necessarily found that Ms. Heard did not lie about being a victim of domestic abuse. False.
No,
that's not what those findings were. That makes them entirely inconsistent.
Nope, that's not at all what they found on Adam's statement.
No, what we did find, and I don't even think we need to read all this. Okay, here it is. Statement number 1, it was a hoax. They accepted that. Statement number 3, it was a hoax. They accepted that. Here's the problem with this one. Quite simply, it was an ambush, a hoax. They already accepted in 2 statements it was a hoax. So that's not the issue what they had with this. That's why they could separate it out. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. Here's the issue. At the time this was done, he had IO's 911 call report, right?
Yes.
And it showed, the only call report they had, it showed came in at 10 o'clock because it was relayed from New York. So they come out, and Amber and her friends spilled a little wine, roughed up the place, got their story straight under the direction of a lawyer and publicist. I don't believe that testimony ever came in to support this part of the statement.
I don't believe it did either. I think that there's more than enough evidence to prove this to be true. And especially the fact that jury didn't find on the other 2, I'm inclined to think that they did, that there was some horse trading in the back, to give her something for whatever reason on the least egregious statement of Adams,
So there's 2 sides to this. One is, did they present evidence that a lawyer and a publicist conspired with them to come up with the stories? That's one side. The other side you're saying goes back to what Ben Chu filed, the improper closing. Hey,
yes.
This decision goes to all women who claim abuse. You're affecting.
No bullshit.
Right. So if what you're saying is true, they threw her a bone. Was it because of the inappropriate closing statement? Because they obviously didn't believe it was a hoax.
Yeah, they obviously did believe that the abuse allegations were a hoax. Otherwise, they would have found her statements for her.
They would have found for all her statements and
For
nothing for
all of
Johnny.
Adams, correct. I would love to know what exactly happened there, because I do think it's interesting. If you clearly don't believe anything that she said on the stand, what is the reason for giving her that piece? It's kind of interesting to think about.
Yeah. I'm checking back. Okay, so I didn't have to read this whole thing because that's pretty much what it was about. And we can agree, both of us, that they can find for this statement. And because they're trying to equate that Ben said, hey, this is essentially a mirror image defamation claims asserted against only two people who truly know whether it's a mirror image. If Mr. Depp did not abuse Ms. Heard, she indisputably knows her claim that he did is false. If Mr. Depp did abuse, then Ms. Heard, then Waldman calling this are false. But we know that's not what happened. They can find that it was a hoax, but that Adam maybe went too far in the detail by including other people.
Yeah, maybe that, or by, they may not have necessarily believed that they set up the penthouses. They believe that she's lying about the abuse allegations, but they didn't believe that she set up that scene in the penthouse, maybe.
Yeah, exactly.
Yeah.
That's what I'm saying. Or that a lawyer actually conspired with people to get their story straight.
Yeah.
Because now you're putting the defamation onto this person's profession, who they tried.
Yeah.
They tried to get her to testify and she got it blocked.
Right.
Mr. Depp's own motion makes it clear the parties' claims against each other necessarily imply that Mr. Depp, so he tried to get her, I think he tried to get her counterclaim kicked because they can't be both. One is answering the other. I think everybody, I've got two great mods in there right now and it looks like everything's going very well.
Good.
The First Amendment bars recovery for defamation by implication when the statements at issue are true on their face and involve a public figure or matters of public concern. We've seen, I'm going to warn you right now, I'm hearing a lot of lawyers comment on this. We've seen in prior motions, Elaine make categoric legal statements with cases, and the judge turns around and says, nope. And of course, Ben Shu's also going to file.
Yes.
Against with his own legal stuff. But we saw it when she was doing her plea and bar. She said, what is it? This is a first look case. In other words, there had never been enough in Virginia, there hadn't been any rulings to support the plea and bar to not support bringing in the UK judgment. And the judge was
Judge
like,
A was like, no.
What do you mean this isn't this is not first impression? Which she's now trying to claim.
Again.
Yeah. And this is going to come down to, she's using the facts in Pendleton, which Ben Shu also used. In Chapin, the court considered a libel claim in which the defendants were members of the press, the plaintiffs were public figures, and the subject matter touched on public concern. In these circumstances, the court held the constitutional protection of the press reached its apogee. Here, by contrast, the plaintiff was not a public figure. The defendants were employed by government agencies, but were not officials generally known. The publicity attending the subject matter lasted only a few days, and the freedom of the press is in no way impacted. Now, Ben is citing Pendleton, saying this person was defamed. She was not a public person, but it was a matter of public concern. So how do you separate dissect Johnny out as a public person versus her op-ed on public concerns? So this is going to be a legal impact. I'm going to skip this. I'm going to stick to we're wearing our jury hat and our readers of the op-ed hat, and we'll let the legal eagles deal with whether they honestly think this is a first impression new law or new case never to be decided on in Virginia. Implication, defamation by implication with regards to a public figure. I'm going to go on to the next argument. Oh, this is going to be a good one. And I'm so glad you're here for this, Jax. The jury's finding of defamation by implication with respect to the op-ed headline statement is contrary to law and unsupported by the facts. The jury's verdict with respect to the headline should be set aside because under the applicable law and facts, Amber Heard neither A, initially made it or published it, nor B, republished it through a tweet. The headline statement, "I spoke up against sexual violence and faced our culture's wrath." This
Well, the
has
jury
to
found that
change.
she did. So fuck off. That's it.
I don't remember hearing any testimony from anyone other than Amber Heard that, yes, she did not create this title.
Correct.
I don't remember the ACLU guy going, yeah, I don't know who made the title. It definitely wasn't her.
I don't necessarily recall that, but it doesn't mean that it didn't happen. But the ACLU gave enough evidence to shoot themselves in the face, with the emails that they had going on behind the scenes.
There's no support for the conclusion that Ms. Heard initially made or published the headline. The newspaper added the headline, and Ms. Heard played no role in authoring or publication of the headline statement. To establish a defamation by implication, Depp must prove the elements for each statement at issue, including first and foremost that Ms. Heard made the headline statement. And there is no evidence that she ever made the headline statement. I guess that's why she didn't have to testify that she didn't. But Jax and I had some big conversations about this way back when it first came out. I'm going to remind her.
Yep, I'm sure I recall.
So I want to go quickly let me stop this for a second. And because we're kind of getting into the implication part of it. And I'm going to try and share another tab here. Amber Heard op-ed. Here we go. Let's just take a quick gander at this one. This I was able to limit down to 2018. So this is the original Washington Post. Amber Heard pens op-ed about the allegations against Johnny Depp. There it is. Amber Heard's
and that whole USA Today article too.
Yeah. Aftermath of Amber Heard on the aftermath of Johnny Depp. Pens op-ed where Johnny Depp. Amber Heard, the ex-wife of Johnny Depp, he accused him.
Yep.
Amber Heard writes the op-ed. Everybody kept going. Even the Mary Sue, everybody was saying, look, it's about Johnny Depp. She pens op-ed about her experience, Johnny Depp. So there it is. It's all there. But here's something that I remember when the op-ed came out. The timeline is important. I'm going to pull up my timeline here. On June 1st, Depp sued News Group newspapers. What is the one thing that News Group was going to need to defend themselves? Amber Heard.
A witness, Amber.
They're going to need Amber. She was the only one that was going to save their butt.
Yeah.
When they printed the article, all they had was a couple of allegations she made, right?
Yeah.
But she had this one sentence in there where it said, throughout our relationship. So that they knew if they could get her as witness, they could really destroy Johnny at that point.
Yeah.
But guess what? Amber wouldn't testify. And we talked about this at great length. Like, would she really go under oath and testify to all of this knowing that she wouldn't do it back in 2016? There's no way.
There's no way.
No way. But then we find out, this op-ed comes out, and we see the title. And what is the one thing we all jump to? Oh my God, she's going to Me Too Johnny.
Yeah.
To get him to drop the case.
Yeah.
Every
Luckily,
one of us.
Like Ben said, it was just me.
Yes, luckily it was just me. But back then, everybody was coming out with these essay allegations, and men were immediately getting vilified and fired, and no one was working with them. And there was no justice. There was it was no innocent before you were guilty. And we all felt that she was going right toes to the line with that title. We all read it going, oh my God, she's claiming Johnny did this. And it only takes a few. And we were the vocal ones. And how many silent ones sitting there in Hollywood were like, okay, now she's going to Me Too Johnny.
She's going to do it.
Yep. So let's pull up. And this is the exclusive I promised y'all. Let's see if I can get it out there. Come on, load. There it is. Okay. So let's share. Oh, that's going to be interesting. this is an exclusive that a lot of people didn't see. And is it this one? Yeah. Johnny Depp's first witness statement. Yes, he made a witness statement outside of the original court. What happened was NGN filed to dismiss the case. The Sun filed to dismiss the case, claiming that Amber Heard refused to testify unless Johnny Depp waived the entire confidentiality statement.
Right.
So this is where it gets good. And I don't have to read this whole thing, but basically, I make this witness statement in response to the defendant's application dated November 29th, 2018, which seeks a stay of proceedings until such time as I confirm in writing my former wife, Miss Amber Heard, who is not a party to proceedings, and her legal represents that I shall not at any time seek to assert against Miss Heard any claim of any jurisdiction or right to restitution, damages, costs, or relief, etc., basically based on their disclosure, on their confidential. But look at this. November 29, 2018. Amber Heard knew before she wrote that op-ed that she was going to have to be a witness in the UK.
Yep.
And she fought it and said, I'm sorry, I can't do it because I'm bound to this confidentiality agreement. So NGN tries to get the case dropped and goes to the judge and says, hey, we can't move forward with our case because our crucial witness cannot testify unless Johnny releases her. And Johnny goes on to say, hey, I'm not stopping her.
Exactly.
There's no reason she can't testify. And then Amber's stuck. And what does she do? She writes that op-ed with that title.
Yep.
And we talked about this to scare Johnny off and to get him to drop the case. That was our impression, wasn't it?
Yeah. Yeah. That's exactly what you wanted to do.
So any of us reading this op-ed, as soon as we read that title, we were like, holy shit, she's doing it. She's going for it. And she did.
Yeah. And a total rebuttal to his GQ article.
Right.
That had come out just before also.
We talked about that a little bit too. So June 1st, he sues in 2018, he sues the UK, the Sun. He talks to the GQ UK article comes out. What? I think it was July or August.
I think it was later than that. I think it was October. I could be totally wrong.
It could have been September. Comes out and says, look, this isn't me. I would never do anything like this. This person shows up with a bruise that nobody saw a few days earlier. The police were there, asked her if she needed medical help. She declines. I'm just not that person. So in October 2018, she takes him to court, arbitration court, claiming he violated the confidentiality clause and she wants all this money. And the judge goes, nope, he didn't do anything. So then she finds out she's going to be a witness. She's trying to find that. Then she writes the op-ed. So there's a lot of causation here, not just correlation, but a lot of causation.
Yes, a lot.
And we are the only ones reporting this because nobody else knows about this. Everybody was looking for that first witness statement. There's no evidence that Miss Heard ever made the headline statement. As required for defamation by implication, the newspaper added the headline. The plaintiff must prove the defendants made the statements alleged in the complaint. The undisputed evidence established that Miss Heard never wrote the headline. The newspaper added it without any involvement in Miss Heard. She also never attempted to correct it.
Nope.
Because when the GQ UK article came out in print, they had some egregious errors in there. They put it online.
Yes.
Johnny's people contacted them and they corrected it. So it's certainly capable of doing it. The UK article, once Johnny sued, they changed their title. Yep. There's no reason if she didn't write that title, she could not have had it corrected. Then she has the audacity that, well, when I retweeted it, I didn't read the article. I didn't read the headline.
That's ridiculous.
Well, first of all, right, she didn't retweet it. She had to go out in the interwebs and find that article. Copy the link, go back to her tweet, create the tweet, embed the link. The article pops up, you see, and then she added to it and said, hey, I published this. Look at me. Look at me. Yep. I published this.
Yep. She took full responsibility for that whole thing.
Mhm.
Today, I published this op-ed in the Washington Post.
Yeah. Let's see what else I got. I don't know if it's going to let me do it. Oh, bummer. Give me 1 minute. So she makes no attempt to change it. She claims that she can't, she had no idea that it was even there. Oh, I saved an image and it's not letting me. Let's see if it lets me put it over there. Anyway, she posted it on her Instagram account also.
Yep.
She didn't just tweet it out. She posted it there too. So it's very clear. It says, today I published the op-ed in the Washington Post. And what else did she write? Oh. Today I published the op-ed in the Washington Post about the women who are channeling their rage and violence and inequality into political strength despite the price of coming forward. For college campuses to Congress, we're battling together. And there's the title is there. So not only did she tweet it, and maybe I didn't see the title. My point is, and I'm trying to show it, she screenshotted that title. She screenshotted her tweet and posted it on Instagram where you can clearly see the title. So this is not holding up at all. Not at all. Sorry.
Yeah,
so that's
she
that.
published it.
Yeah, for sure. For sure.
She wanted that title. She wanted all that inference.
Yeah. So going further on, this is another legal thing. They're going to argue about defamation by implication. No reasonable jury could conclude that Ms. Heard published the headline. To prove publication is generally sufficient to show that when the defendant addressed the defamatory words to the plaintiff, another person was present, heard the words spoken, and understood the statement as referred to in the plaintiff. Now, the jury was given instruction and the option of what republication was, and it was up to them to decide if that tweet was republicized to a new audience.
Right.
Amber Heard currently has, that post that I referred to on Instagram, for example, has 43,000 likes. She currently has 5.3 million followers. That post is still there. She didn't delete it. I don't think all 5.3 followers of hers or those 43,000 people who liked it all read the op-ed article, all read the Washington Post. They might not have even known about this. So she reached a whole new audience by doing this. And that's what's important.
Yes.
Ms. Heard's tweet linking the newspaper article does not constitute republication under applicable law and fact. Virginia follows a single publication rule, but this went through with the jury and they were given the instructions by adding the commentary. Did it change it? Tweeting a link does not constitute republication. She didn't retweet a link. She created it. Even if the tweet includes a mere reference to the article, a mere reference. Republication requires editing and transmitting the defamatory material or redistributing the material with the goal of reaching a new audience. Well, I jumped ahead because we just showed that she definitely was reaching a whole new audience.
Absolutely. People that are following her for her movie shit or whatever aren't necessarily reading the Washington Post.
Right, exactly. Yeah. They may not have even known about the op-ed until she tweeted it out to that. I mean, correct. Most likely 80% of because let's say the Washington Post is not Deadline. It's not Variety. It's not TMZ. It's not the typical thing that I sit down to read, not the Washington Post, unless maybe I live in that area, which is why he sued there.
Right.
There's the New York Post. There's the Chicago Tribune. I mean, there's a lot of big newspapers across the country that would not be carrying this op-ed. It was an opinion article, not a news article.
Right.
So a lot of people would not have read it until it was publicized and then retweeted by her, In fact, that tabloids like Deadline probably picked it up from her Instagram post and her tweets more than they did from the Washington Post. Although
I
think
agree.
they also sent it out, I'm sure.
I agree with that for sure.
And moreover, a brief reference to the linked article does not constitute editing the article. The tweet, which it wasn't about editing, it was redistributing. She definitely redistributed it. Although Ms. Heard's tweet called attention to the article and indicated she was the author, the tweet did not edit or add content to the article in a manner sufficient to overcome Virginia's single publication rule. The jury didn't agree. She keeps saying the jury got it wrong. The jury didn't agree. Ms. Heard also, wait.
You don't get to just set aside the verdict because you don't like what the jury said. Like, sorry, that's not how this works.
I got scared for a second. I thought I missed somebody. They were saying the OGs are back, and I'm like, oh my God, who else came on that I missed?
Oh no, I don't see anybody. But no, the same thing in London. You know, Johnny doesn't get to set aside the verdict because he doesn't agree with what the judge said, even though we all disagree with what the judge said. That's not how that goes, unfortunately.
No. Ms. Heard never redistributed the headline statement with the goal of reaching a new audience. Well, we just proved that's false. Not only did she tweet it, it's on her Instagram, and I guess I'm disappointed Johnny's team didn't pick that up because she's a hell of a lot more followers there. Ms. Heard also never, and the fact that it was a screenshot, she saw the freaking title. She can't say she never saw it. Ms. Heard also never redistributed the headline statement with the goal of reaching a new audience. Bullshit. Tweeting a link to a prominent global newspaper does not redistribute the material to a new audience as a matter of law. That's going to be for the judge to decide.
Yeah.
A lot of case law. She did not retweet it. I hate when they say she retweeted it. She went out to the interwebs, found that link, wrote a tweet, embedded that link, and then she tweeted it out to new people. Then she took a screenshot of it. In short, Ms. Heard never affirmatively reiterated the headline as required for republication on the law or facts. A mere link and brief reference to the online article in a global newspaper is insufficient to constitute affirmative reiteration under the law. A tweet which merely refers to the article is not republication. She didn't merely refer to it. She embellished it. Moreover, there's no evidence reasonably supporting a finding that Ms. Heard republished the headline by linking a tweet to a global newspaper article. Ms. Heard had no control over whether her link to the newspaper article included the article's headline. Well, she had control over tweeting it out. I mean, she knows they're acting like she's stupid. She took a screenshot. She knows what she's done.
Yeah, exactly.
Ms. Heard never typed the headline in her tweet. She simply linked the article with a short reference that did not restate the headline. It did restate the headline because when it printed it out, you could see the headline. Mr. Depp did not present evidence of actual malice.
No, please.
This is another legal thing. Public figure may not recover damages for a defamatory falsehood without clear and convincing proof that the false statement was made with actual malice.
Well, the jury thought there was enough proof.
Dan Wooten, when he wrote his article, went off of the DVTRO, thought he had reason, even though it was temporary and not proven, he reasonably thought he had a right to do that. That would not be actual malice. They could still prove he made a mistake. He still proved that it was wrong. But he himself didn't do it with actual malice. Amber Heard is the writer. She's the first party person who experienced this, and then she wrote about it. She's the only one knows what's true or not true. And as Elaine says, the jury found her to be lying. And so if they found her to be lying, right? Lying liar keeps lying. That's actual malice.
That's lying is malice. Like, hello.
To establish actual malice, a plaintiff must demonstrate the defendant realized that his statement was false or that he subjectively entertained serious doubt as to the truth of his statement. Whoops. She knows she was lying.
Yes.
Courts have a constitutional duty to exercise independent judgment and determine whether the record establishes actual malice with convincing clarity. I think that was pretty clear. She would know. This rule of independent review assigns to judges a constitutional responsibility that cannot be delegated to the trier of facts, whether the fact-finding function be performed in this particular case. She's talking about the jurors. There is a significant difference between proof of actual malice and mere proof of falsity. Again, They could have proved Dan Wooten what his statements were false. Not that he knew they were false when he first wrote about it, but they were false.
Yeah.
Discredited testimony of the defendant standing alone does not constitute clear and convincing evidence of actual malice. Rather, the plaintiff must present affirmative evidence that the defendant acted with the requisite state of mind. I can't believe this. A determination of actual malice cannot be predicated on the fact finder's negative assessment of the speaker's credibility at trial. Conversely, a jury finding the plaintiff's testimony is credible does not establish actual malice. Well, they found her not credible. They found she lied.
They did not find for any of the other actual hoax statements that revolved around abuse. Like, dude.
The fact that an
You
impartial
lied.
jury unanimously reached the conclusion that the plaintiff, Johnny Depp, was telling the truth does not, however, demonstrate that the defendant, let's substitute Dan Wooten, act with actual malice. However, it does demonstrate that Amber Heard acted with actual malice because she knew she was lying.
Yes.
In short, evidence of falsity alone is not sufficient to prove actual malice. In this case, proving actual malice required showing that at the time the op-ed was published, Ms. Heard did not believe she was abused or that she entertained serious doubt about whether she was abused.
Oh, bullshit with this believe I was abused thing. Like,
my God.
you came in there with these ass claims saying you had these horrendous ass injuries, and then you have like a smudge of eyeshadow. Get out of here.
So here we are at the closing with Rottenborn saying the definition of abuse is emotional, physical, financial, mental, all of that. There was no jury instruction given to the jury that they have to define abuse in this manner, and does it meet the threshold? Thank you, sweetie. I appreciate it. Ariel Higgins. What they had to, almost hit the wrong button there. I almost hit end broadcast instead of open the tweet up. Anyway, they had to, what were we talking about? Because actual malice is, okay, so Rottenborn says all kinds of abuse has to be considered. Luckily, Camille comes out and says, no, this op-ed said 2 years ago she got a DVTRO. Within that DVTRO, she stated what happened to her, which was physical abuse.
Allegations of physical abuse. Yes.
Well, she wasn't even alleging it. She was claiming it in that thing.
No, yes. Right.
So now we have all this testimony. If they really believe that, Ms. Heard testified unequivocally that Mr. Depp abused her physically, emotionally, and psychologically, Mr. Depp presented no evidence that Ms. Heard does not believe abuse can be physical, emotional, or psychological. But it was referred to the DVTRO. And the jury nobody believed her. Once she got on the stand and started making all these additional claims, photos that don't match up, or they match up too much because they've obviously been filtered, the same photo, then she lied. Then they have a right to do that. As far as she believed when she wrote the op-ed, she believed she had been abused. She arranged for this first meeting to violate the TVR. She did that. She wasn't afraid of him.
Not one bit. She would take him back tomorrow.
She tried, yeah. Mr. Depp intimidated Ms. Heard by kicking the cabinet's doors and screaming, upsetting, and smashing glasses. He didn't smash glasses. He also did not know she was there. She snuck up behind him and stood there and then set up the camera, hoping to catch him. He had no idea he was there before when he started acting out. And when he did, he calmed down and stopped until she kept poking at him and poking at him. He also destroyed property in her presence on other occasions. Mr. Depp testified that he punched a bathroom sconce that was right by the mirror during an argument in Hicksville. Mr. testimony that he ripped a phone off the wall in Australia. Actually, he didn't testify to that in the USA. That came up in the UK, and he was quite confused because he thought
they kept saying it to him. Sasha kept saying it to him. Yeah.
That actually happened during the time that he was incapacitated mentally. I mean, he was bleeding everywhere. He goes, I don't remember doing that, but I guess they're telling me I did that.
Right.
While fighting with Miss Heard, Mr. Depp pushed over clothes and racks and shoes in the closet. Whitney testified, I thought that they were back in her room. It wasn't until they came out of the room and they saw the mess. Mr. Depp forbid Miss Heard from acting in movies and having meetings. There's a text message. No goddamn meetings, no movies. Why do you deviate from our agreement? That's not forbidding. That means they had a prior plan.
They had plans.
And I still can't believe they're relying on this. I have other uses for your throat which do not include injury.
Oh my God.
They actually put this in there.
These come on, man. Also, if you read the rest of the texts there, it's very clear what's going on.
Right. Mr. Depp repeatedly accused her of infidelity, promiscuity, and let's see, using paint in his own blood. Gee, where'd the blood come from?
Yeah.
She chopped his freaking finger off. That's
this weaponizing.
Part.
Yeah.
Go ahead.
This weaponizing of his eccentricities or whatever is so, cruel. Because he does, I think we talked about this a little bit on the podcast, like, drawing on countertops or walls or whatever. Maybe people think that's weird or whatever. That's obviously his outlet for emotional upheaval. And weaponizing it like that is so cruel,
Mr. Depp accused Ms. Heard of having affairs with co-stars. True. It's not emotionally. I mean, she got called out and got caught, and that's emotionally abuse. She was cheating on him.
Yeah. A lot.
Oh. I saw something. The noise. What was this? Somebody was saying something about noise. The noise that kept playing from the plane. Oh, okay. Yeah.
I think that's in the Bahamas.
I think it's in the Bahamas. I think it's the fans going and things like that. Because they saw that net screen, that the mosquito netting around the bed.
When they played that video that Tara took, I think I was sitting next to Brian that day in court. I immediately grabbed him and I was like, I think this is what that audio is, because you can hear the buzz of the fans or like a generator or something in that video.
I think you can hear the generator because I looked, the fans weren't running in that video, but you could hear that hum.
Right. Like a hum, exactly. That sounds way more like what that is than.
And you
an
also
airplane.
in the video hear kitchen noises, utensils and stuff. That's a one.
Yeah.
I mean, the kitchen's right there next to the bed.
It's just like a cabin.
Yeah.
Yeah.
It's basically one room. It's only divided by furniture, not by walls.
Mm-hmm.
Oh. I become irrational when you're doing movies. I become jealous and fucking crazy, weird. Okay, they fight a lot more.
But she doesn't.
But I remember the testimony that she would say that she would tell Johnny things are way worse than they actually were. So that's
exactly what I meant. Correct. She would do it. She would rile him up about it, make him think that things were bad on set with rapey Franco and all that shit.
Mm-hmm. The question is not whether the jury rejected that the above conduct constitutes abuse as an objective matter. The question is subjective. It is whether Mr. Depp proved that the events did not cause Miss Heard to believe she was abused. Mr. Depp presented no evidence that Miss Heard seriously doubted that she was abused and thus failed to prove actual malice. Seriously doubted she was abused. Okay, maybe if she didn't bring all that other testimony of all those other abusive allegations, she obviously thought she was abused then. So the jury's supposed to sit back and go, oh, well, she lied about all this other abuse that she presented to us, but she was actually really still abused. I mean, I don't think the jury could separate that.
No way, dude. And if that's the case, then you need to say that you have mental health issues on her part, that you just have this propensity for making things up,
Yeah. Yep. Okay. I do have something here. Okay, so there was a hearing. We're going to talk about this. Moreover, while domestic abuse is not limited to physical abuse, it's undisputed evidence established that Depp participated in physical fights. I never saw anything that he participated. He testified, and we're going to get into this, the headbutting. I headbutted you in the fucking forehead. That doesn't break a nose. It's interesting how they limit to that clip. And this is really
No,
important point
that's
for the
trash.
UK. So Johnny did not participate in physical fights. He testified that he was being wailed on. He bear hugged her arms to try and get her from hitting him. And in doing so, they knocked heads. Her original text to Raquel was that Johnny said it was just a little knock. That was the original text.
Yes.
This day in San Francisco, July 2016.
Second.
Yeah.
Oh, yeah.
She's recording the conversation and she gets him talking about that. Let's jump to the UK. So this was a big deal in the UK because I don't know if I can find that to share it. But they had a big hearing because they were submitting a 3-second section of audio tape that was about this. That's all they had. Yep. And they're like arguing, like, wait a minute, this is out of context. There's more to that. There has to be. And Amber Heard's lawyer is there, like, no, it's all inaudible. This is all we have. And Johnny goes, excuse me, Judge, we need you to compel her to turn over the full tape and we'll decide what's audible or not audible or what we can transcript. Because this is unfair that you're just giving us 3 seconds of I headbutted you in the fucking forehead that doesn't break a nose. Yep. The judge declined. The UK judge declined, saying she is not a party. She's only a witness. Yep. I'm not going to require her to provide anything. They say it's inaudible. They say the audio isn't better. So I don't see any point in doing this. Amber, this is what gets submitted in the US. Maybe I've been screaming. It's like somehow the end all be all of some offensive thing. You can throw a punch, but yet screaming's okay. You can headbutt somebody screaming, but don't scream, huh? Johnny says, I headbutted you in the fucking forehead. Amber, I couldn't believe you did that. He goes, that doesn't break a nose. Amber says, I don't know if you were aware. I don't think you did. I don't think you broke it. Johnny said it was an accident, not intentional.
Exactly.
And here she's saying, and this is what they left out of the UK court. I don't think I broke it. Oh, please. You didn't touch it? You don't know. You don't know what you did. There's nothing wrong.
That's always her default.
Yeah. Just like you didn't throw a phone at my face, right? No, I didn't throw a phone. All of that was cut out. All of it.
Yep.
So this was supposed to have been submitted to the UK. And I wish I could share it, but it's giving me a hard time and not letting me share it. So bear with me.
And now in that whole 4-hour audio, we have him coming at her about throwing the bottles.
Right. Here's what she testified to in the UK. I had bruised ribs, bruises all over my body, bruises on my forehems. There's chunks of hair missing. I was purple and red all over. She testified that Johnny, with intent, put his fist to the side of his body, leaned back, and headbutted her right in the nose with intention and full force.
Oh, yeah. It was like clenched his fist, reeled back, and smashed his head into my. Yeah.
We have her on this audio now saying, I didn't think you were aware. I didn't think you
Exactly. Exactly.
That's what was kept out of the UK. Not that the judge would have paid attention because he discounted every single one of her audios except this. This is the only audio he allowed in. That statement.
Yeah.
Everything else he said, well, it's out of court. I can't use it.
Trash.
Oh, total. Just catching up a little bit. Yeah, if she was really headbutted, she would have had a massive cut. She would have had massive injuries. Her eyes would have been swollen shut. Isn't
exactly.
insane? So we know there's the audio that existed.
Yep.
Jax is bored discussing and debunking her lies over and over again. No, she's not bored. Angry. It's angry that
it's not
end.
It's not boredom. It's like, why do we have to keep on doing this? You know what I mean? It's not boredom. It's like, holy shit. How many times do we have to say the same thing over and over again? You know what I mean?
I know. And we can't be quiet because we can't give the lies freedom.
Yeah, it's frustration.
So this
Oh,
is
we
going to be
got bots.
another. Yeah, this could be another legal paragraph. When a plaintiff claims that he's been defamed by statements that are literally true because of a false implication arising from them, the implication must be reasonably drawn from the words actually used. The statements that are literally true. Okay. In such cases, the plaintiff may prove defamation through innuendo. I thought it was referred to as implication, an explanation of the alleged defamatory meaning of the statement. The provenance of innuendo is to show how the words used are defamatory and how they relate to the plaintiff, but it cannot introduce new matter nor extend the meaning of the words used or make certain the amount of fact. Well, she referenced 2 years ago.
Yeah.
No evidence surrounding the op-ed's publication would reasonably cause a reader to believe the title of the online edition is about Mr. Depp. We all did. There was a whole bunch of us. We're going, she's Me Tooing him. She's doing this to get him to drop.
Who else would she be talking about? Who else would she be talking about?
Yeah.
2 years ago.
Yeah.
Jesus.
2 years ago. By college age, I had suffered SA. Well, first of all, she never went to college, so I thought that was interesting the way she kind of slid that in there.
Yeah.
You know, college age, if you go into masters or whatever,
By the time you were 18, I don't, what does that mean?
Or even, no, it said something about college age.
Right.
Oh, when a plaintiff proceeds under a defamation by implication theory, he must prove that in light of circumstances prevailing at the time the statements were made, they conveyed a defamatory implication to those who heard or read them. We all did. The jury did. There's no, I just showed you a Google search for sure. I'm going to have to read this all. In other words, Mr. Depp's theory was allegations of sexual assault made after the op-ed's publication and after the commencement of the instant action caused readers to understand the title to be about Mr. Depp. They're saying that it wasn't until she made the sexual assault allegations in the UK that it came to light, that then they turned around and said, yeah, this title is referencing Johnny. And you and I had those conversations. We do not agree at all. We definitely took the title right away to be about Johnny.
Yeah, exactly.
And we're the readers.
And so did half the press.
And so did the jury, which is the fact finders.
Yeah.
Consistent with counsel's opening statements at trial, Mr. Depp presented no evidence that prior or shortly after the op-ed's publication, Ms. Heard accused him of sexual abuse. The only evidence of prior allegations of sexual abuse was Ms. Heard's testimony that in the UK kingdom provided confidentiality when testifying. See, again, we disagree with this. During the heightened Me Too movement, she comes out with this op-ed clearly mentioning 2 years ago, I became clearly making sure everyone knows it's about Johnny Depp. And there's the title. Yeah, that was a warning shot. Drop the case or I'm going public. I'm going to talk about this.
Mm-hmm.
Nothing in the op-ed suggests the title is about Mr. Depp. The title states Ms. Heard spoke up against sexual violence, which does not suggest she spoke up about violence by a particular person as opposed to violence in general. Well, she did say about a particular person because she said, I became a DV spokesperson 2 years ago. Yep. She pinpointed it. Here it is. I've been harassed and sexually assaulted by the time I was of college age. Well before she met Mr. Depp. Not well before, because she was what, 22? That's still college age. That's not well before.
That's still college age. But she's saying, she's trying to say by the time that's 18-ish.
Yeah. Op-ed does not include Mr. Depp's name because nothing in the op-ed suggests the title is about Mr. Depp, and he presents no evidence. And it's funny because of all the lawyer commentary we heard, this was the one thing they were sure banked on Johnny was going to win, the defamation against the title. Absolutely.
Yes.
And then she proceeds, instead of saying, yeah, it wasn't about him, but oh, by the way, let me tell you about a bottle. And oh, by the way, let me tell you about this. So she completely conflated the whole thing in the court, in the case itself. If the jury was led to believe that Mr. Depp, that title was about Mr. Depp, it's because she put it in their face so many times and tried to cry about it.
Yep.
And then her dog stepped on a bee. She tells this terrible story. Wasn't it in Hicksville? This terrible thing that happened to her. And then I had to go to the vet today because my dog stepped on a bee. That was the worst thing that could have happened.
Right, when the guy was wearing a mesh shirt and all this shit, and then here comes Morgan Knight out of the woodwork like a G. God.
The title, Sabs says the title links to culture wrath that wouldn't allude to pre-JD. Well, that's a good point, because she's tying her op-ed into what's going on right now with men being accused of these terrible things and nobody actioning about it. So she's kind of playing both sides of the fence here. Ooh. At trial, Mr. Depp's theory of defamation was that the op-ed implied Mr. Depp abused, I'm almost to the end, misheard. Counselor, opening statement. The clear implication of Ms. Heard's op-ed was that she was a victim of DV perpetrated Mr. Depp. Mr. Depp maintained that this implication arose from the op-ed because on May 27, 2016, she obtained a domestic violence restraining order against him. They're making the case for him. Yes.
Yep.
2 years ago, she did. On May 27th, Heard walked into the courthouse in LA, California, to get a no-notice ex parte restraining order against Mr. Depp, and in doing so, ruined his life. In sum, Mr. Depp argued the circumstances 2.5 years before the op-ed publication in December caused it to be defamatory. Yep. And the jury agreed, because they're the fact finders. They're going, yep, 2.5 years ago, 2 years ago. The only thing that she can write about to become a DV spokesperson is because she made claims against him.
Yep.
No court in Virginia, however, has ever permitted circumstances so distant from a publication to serve as innuendo, showing the publication conveys a defamatory implication. When the publication on its face does not show that it applies to the plaintiff, the publication is not actionable unless the allegations and supporting contemporaneous facts connect the words to the plaintiff. Oh. Well, I understand. I was watching Uncivil Law, and he was talking about how many degrees of separation does it take for you to get there?
No, 0.
Said, 1 step. I was the spokesperson of DV 2 years ago. 1 step, and you're there. He argued that after you read the article, then you might go back to the title and like, oh, it's talking about Johnny Depp. That might be too many steps, is what he was suggesting, but we clearly read it right away that this was
the whole fucking media said that USA Today article that they used in court was a bombshell, and there's 100 other ones like you already pulled up earlier.
Mr. Depp cannot recover for statements Ms. Heard made during judicial proceedings, and he failed to prove that any statement in the op-ed implies he abused Ms. Heard. Okay, this is what drove me crazy with TMG. Let me see. Here we go. So Johnny Depp sues TMG. TMZ countersues him and writes the most heinous smear campaign in their motions, knowing motions are privileged. Anything they write in there, they cannot be sued for defamation as long as it's in a motion. Now, they're supposed to be able to prove these things. But they went on and on and on. And I have this quote here. The pages of allegations of Depp's allegedly outrageous spending clearly have no relevance to the 5% commission alleged owed to TMG. TMG was what they were counterclaiming for. Or to the final work done by TMG on transitioning their files to Depp's new representatives. That's what they were suing for. They were suing for back pay and how much it cost them to do these files. All these other outrageous allegations had nothing to do with their claim. They were strictly putting them in there so the media would report on them. They would seem more relevant to the allegations of breach of oral contract related to the credit card debt, except that TMG does not specifically allege which exact expenditures by Depp were spent on which card. They have no idea who were using these cards. Jumping ahead, Adam said yesterday, Judge Bidet dismissed the Mandels. I know, that's what it says.
It is what it says.
Maybe it's Baudet, Beau.
Let's hope.
Dismissed the Mandels' declaratory relief claim, and here you go. Struck from the cross complaint over 80 paragraphs of allegations containing frivolous smears against Johnny Depp, which constituted their PR defense.
Yeah. And don't forget they hired David Shane.
Right. But you can't sue someone for defamation about what's written in the motion.
No.
What they're trying to say now is you can't lay claim to Ms. Heard for what she wrote in her DV TRO application. Mr. Depp has attempted to bootstrap statements that are protected by judicial immunity and time barred to the op-ed through a claim of defamation by implication. This attempt failed.
No, because she made the statements publicly. It's not only that she wrote it in the TRO, she said it to fucking People magazine.
There you are. And what else did she give to People magazine? Not just words.
All the photos and everything.
Yeah, that's not privilege. Once you're putting it out to a third party, it's not privilege anymore.
Exactly.
This attempt failed only because only implications that can be reasonably drawn from the words actually used. 2 years ago, I became a public figure representing domestic abuse. I think the jury found that pretty clear. Hey guys, we got some.
They'll get it.
Okay. In fact, they'll get it for me. Okay. Oh, thanks, guys. 2 years ago, I became a public figure representing domestic abuse. Could remind such a reader that Ms. Heard obtained a restraining order. It did, against Mr. Depp. But a reminder of statements made in a judicial proceeding does not amount to the republication of those statements. Like you said, People magazine, even if they were going to remotely try to do that.
Yeah.
I tried.
Damn, Laura, don't you wish now we had done The Road to Fairfax as a YouTube series?
Yes, I do. For sure. Yep. I do.
Yep.
Damn. Oh. Anyway, to hold otherwise would treat defamation by implication as a republication doctrine, improperly allow the introduction of new matter, and would permit recovery for the innuendo itself. Innuendo cannot introduce new matter nor extend the. She's not introducing new matter. She's claiming allegations of abuse, which the jury clearly believes she lied. Mr. Depp did use innuendo to show that the op-ed conveys that he abused Miss Heard. He was attempted to recover for the innuendo itself, Miss Heard's testimony to obtain a restraining order in a judicial proceeding. Accordingly, the jury's verdict in favor of Mr. Depp should be set aside. Again, she didn't limit it to it. She went out to the world, and not only did she do the People, but she was on the speaking circuit about being a victim of DV too.
Exactly. And she was getting like $35,000, then like $50,000 and upwards from there to do these speaking engagements about the whole shit. She totally capitalized on a bunch of lies.
Here we go. Let's see if I can get this up. So now that we're going to get into the juror. Please load for me.
This is hilarious.
This is like, I mean, it could be scary, but I think it's an innocent accident. The court should investigate.
I think it's like a clerical error.
Well, I'll give an example. The court should investigate whether juror 15 properly served on the jury on the juror panel list sent to the counsel before voir dire. On the juror panel list sent before voir dire. The court noted that the individual who would later be designated juror 15 had a birth year of 1945. You and I sat there. We saw these jurors. We saw them being questioned. So we know what they look like. We saw them sitting. That guy did not look like he was born in 1945, and they'd have to be damn blind. They overlooked it. They had the information themselves, and they ignored it. Juror 15, however, was clearly born later than 1945. Publicly available information demonstrates that he appears to have been born in 1970. This discrepancy raises the question of whether juror 15 actually received a summons for jury duty and was properly vetted. Here's something interesting.
Somebody showed up to the courthouse for funsies to get on. I mean, come on, man.
Right.
I think it's just a clerical error.
Yeah. Or it's personal error. Ian made an interesting comment that what if they did notice and Elaine wanted something in her back pocket and said, hey, that guy doesn't look 77 years old, but it's not our mistake. So let's just file it back in case we're going to need it. Wouldn't that be interesting?
Yeah, but he also said that the court will be like, F you about it. Like, you should have said this during trial. That's
what the point. She should have. And if she is tricking the trial saying, oh, yeah, I noticed, but I didn't do anything about it, that's not cool at all.
No.
So let's see if I can bring this up. I tried everywhere I could possibly find to look for a Fairfax County juror sample, and I could not find one. But I found Chesapeake, which is practically adjacent to Fairfax. Yeah. Here's a juror summon, name and address, and the dates you're going to show up. And here's your juror identification badge for when you get there, and it has a barcode. What if John A. Smith lived with his dad, John A. Smith?
I thought
Sr.,
about this too.
who's 77
Yeah.
years old. My mom's been living with me for 30 years. We don't share the same name, but let's just say we did. If I own this house, this is my
But I
address.
think isn't there a certain point in time where you age out of being?
You only if you request. I looked that up. Anything
Okay.
over 75, you can automatically say, I don't want to serve. But it's up to you
Okay.
to say, I don't want to serve.
I gotcha.
But mistakes happen all the time. So we got John A.
All the
Smith.
time.
Maybe the dad that lived with him has passed away. And voter registration hasn't caught up with it yet.
Yeah, and like he didn't notice, or you just assumed that it's for him.
Well,
I
there's
don't even
nothing
know
on
what
here to
you do.
notice unless he always went by John A. Smith Jr. Not everybody
Yeah, it
does.
doesn't give your birth date, right?
Right. And there's the juror badge, and there's your parking permit. But there's nothing on here that would scream to him, hey, you're supposed to be 77 years old. Now, when he
Exactly.
gets there and checks in and they scan the barcode, and again, this is Chesapeake Bay, which is right nearby, then they would see, for sure. They would see that this ain't you. So there
Right.
was an error done. I don't think it was an intentional.
I don't think
I don't
it's
think-
anything. It's the same actually as looking at that one medical note for Amber that says like well-nourished male. You know, it's like this is irrelevant. This is just a form. Everything else is very clearly, it says her name, it says this, it says the other thing. It's just like a template.
I just can't believe that some guy got his hands on this. Let's say they're sitting in the jury room. Oh, I think I've lost my mods.
No secret squirrel is there.
Oh, okay. Yeah, it says an error occurred, so they must be blocking them, and I'm not seeing the block.
It's all right.
So I can't believe that we've got a guy sitting in the jury waiting room, and he goes, "Oh, you're getting on that case. Let's exchange juror summons, and I'll do."
No.
They don't know what case they're going on. People, we were there.
No.
Jackson and I sat there and watched this. They had no idea. They were,
And I've been through it myself before. You don't know until you get to the voir dire.
And we saw in the hallway, there's lit up boards with all the cases. There were so many cases they were pulling juries for, tons of them, because of
it looked like it looked like an airplane departure screen.
Yeah, because with the beer bug, they were so backlogged in cases. They were bringing everything in, and that was one of the reasons that the cafeteria was running out of food, because there were so many juries, not just so many Johnny Depp fans. That wasn't the point, or
that was not
spectators. There were so many cases going on that they couldn't keep up with the food.
And there was some days they closed the overflow room because they needed to hold trial in there.
Yeah. So if you weren't one of the 100 to get in, you the next 50 weren't always getting into that room.
Right.
Okay. Anyway, they're raising this concern. They want the judge to investigate, which I think is pretty bold, considering they had the information before voir dire. It was their own eyes. They could have questioned it. It's not up to the judge to do your legwork. So I can't imagine this is going to go over well. She's going to say,
"No, I don't think so.
You bring me proof that something bad happened. You investigate this and bring it to me, not the other way around."
Even, I mean, there was. I talked to Ian about that. Like in the Ghislaine Maxwell trial, there was that one thing about the juror who really wanted to get on, and whatever happened there, and that was denied, and that was like overt.
Exactly. I mean, they abused. Michael says, even if that was true, it changes none of the evidence, none of the testimony, none of the lies,
correct,
etc. And that's what we've been saying. So, yeah, absolutely not. So finishing up, the court's clerk's office had a statutory obligation to verify the identity of juror 15, but because juror 15 was not born in 45, it appears his identity could not have been verified through any of the means identification the code provides. It sounds like human error. And it also raises questions.
What you're trying to do is like make this assumption that this other person would have ruled differently. that this other person that you've invented
Right.
would have potentially ruled differently? I doubt it.
You can't know that.
You can't know
I mean,
that.
they got through voir dire. They didn't question him. He wasn't concerned whether he had known about the case, had known about anything. They asked him all the questions they asked every other juror, and they kept him.
Correct.
And they had to have known. So the error is on multiple people, including the lawyers.
Yeah.
Even if he signed his affirming statement under penalty of perjury that he was the named juror, well, he thought he was. He made, again, when I showed you the summons, it doesn't appear, his birthday wasn't on that summons. Although,
Right.
and then I love this part. Ms. Heard recognizes that the code states that any error in the information shown on the jury panel shall not be grounds for mistrial or assignable error on appeal.
So there you go.
So, and then they're trying to suggest that in this high profile case such as this, they should have been more critical. No, everybody's entitled to equal justice. Just because they're more high profile, nothing should have been done specially.
No.
That was just rude. We all get equal justice.
Correct.
So Ms. Heard requests the court take appropriate action based upon the results of the investigation. Nah.
Nope.
For all reasons set forth above and for the reasons set forth in the record during the hearings on the trial and the motions of limine and the motions to strike, thank you, Emily D. Baker, for letting me know how to say limine. Motions to strike. Ms. Heard respectfully requests this court set aside the jury verdict in favor of Mr. Depp and against Ms. Heard, not her part of the complaint, and dismiss the complaint or in the alternative order a new trial. Ms. Heard further requests this court to investigate potential improper juror service and take appropriate action warranted again.
No.
O capital S-H-I-T.
Just say it. Just say that she wins. Just say that she wins. No.
Yeah. Anyway, I just cannot imagine at any point in time that after presenting all these horrific, violent incidents, she has the audacity that basically saying, okay. She lied about all that shit. But she was still emotionally, she thought she was still abused emotionally. But even if
the trash,
even if the verdict came back that she actually lied about all that abuse, she still thought she was abused. I cannot believe her own lawyer was putting that in there.
That's fucking nonsense. And then what? You should be institutionalized because you are not thinking in the realm of reality in that case.
Right. And if anybody's got questions, we got a few more minutes. Please put them up there now. This is a great time. And Super Chats is open. And don't forget to like, subscribe, share, all that fun stuff so I can keep doing these.
All that. Laura's going to come on the Movie Missing Monsters channel one of these days too.
Yeah, well, we're going to bring Brooks. We're going to do a big summary of him, right?
Yes, let's do that.
Depending. My next videos are going to be Johnny's deposition excerpts, the witness list, exhibit list. And then we have Lemonies, which I'm so surprised they made public, but they did because the jury's not supposed to know what was not going to be in.
Yeah, but that's great for us. I'm looking forward to that.
Yeah, I hope. I mean, he still can settle.
Oh my God, how many times do I have to explain my screen name? The name's Q has nothing to do with QAnon, right? Because that would be annoying.
Oh, no. It was lazy. She just stuck her fingers on the keyboard and came up with QWERTY. Q-W-E-R-T-Y.
My name existed long before QAnon.
Yeah.
It was QWERTY, and people just started calling me Q. So I made it the name's Q.
Yeah. But wasn't your at QWERTY? Was it at the name's Q?
On TMZ and on the lounge, it was just QWERTY. And then everybody had started calling me Q for so long. By the time I went to Twitter in March 2019, I just made it at the name's Q.
Yeah. Both sides have had jury consultants to run backgrounds. I would guess so. Surely it's a big, they had the money. They were spending lots of money to do this. Why wouldn't they do jury background checks? They had the list available to them. I mean, you see that's on that TV show. We see that all the time.
Yeah.
If you want a breakdown of the UK trial, this BBB, he goes by channel. He breaks it down. He also makes a huge mistake, and I had to mention him to that. I'm sorry. I'm not calling anybody out in a bad way, but it was an easy confusion. He, in his presentation, said that Amber Heard was never cross-examined. And I think
Yeah,
he
that's not
got
correct.
confused because David Sherborne was doing so many questions. And then when they switched over, Johnny Depp did have a female lawyer that questioned
Yes,
Amber.
Eleanor
And I
Laws.
think there was confusion that they didn't realize it was a female swap. And they just assumed that Amber Heard did not get cross-examined, but she did. We do a great run-up of it on the original podcast, Movies, Myths, and Monsters of The Road to Fairfax. We go through this UK trial pretty well.
Yeah, that's all still up there.
Thanks. Where we go. Don't forget to smash like and is there a pre-jury questionnaire? Interesting. I did Google that. They do send out questionnaires way before, but that doesn't guarantee you'll get a jury summons or get picked. So there are questionnaires, but it's not for everybody. I thought that was interesting when I Googled that. Did you get a questionnaire at any time? Jackson,
Me?
Yeah.
No, because what happened when I went, so usually the way it's done in California is you get a summons, but you don't actually have to go in person. They give you login credentials on the website, and they give you a 5-day period where you log in and see if you have to go to the courthouse. However, due to COVID, they were so short on potential jury members. It was like, you get a summons and you're coming on this day.
Right.
So I went down there, and it was like you were already selected basically to the jury because they had nobody. I mean, I was sat on a misdemeanor domestic violence case saying, like, I'm working on a documentary. I have no people that have been falsely accused. I said everything that should have gotten me thrown off the jury, and I was not thrown off.
Yeah. But you didn't have to do a questionnaire that you can remember.
No, they just were asking questions like we saw out loud, like we saw in Virginia.
Yeah. Secret Squirrel got it. Thank you very much for your help today. Very much appreciate it. We had a few bots in there. The same one as last time. All this like sex stuff.
They just keep like making new handles. Whatever happens. Still believe that Johnny was lucky to get out of that marriage alive. Yeah, me too.
Oh, sorry. One day they said there was lots of jury selection for other cases on days as well. Oh, yeah.
Yes.
The board was packed.
There would be our line to get into the courtroom, and then there would be another line snaked all the way back to the elevators of potential jury members.
I hate that people are through bullying, but do you really think she could be bullied? I assume I'm looking at the conversation. I don't see it. I guess I'm
that people are quote unquote bullying her now online. I mean, getting called out for this. Honestly, I don't feel bad. Like, you perpetrated this hoax over 5 years, 6 years, actually longer in doing it to him. And, I don't feel bad.
She can't stop lying on TV interviews. She said there were 6 blocks of placards against her, but none were seen by media. And she also said they had to put secure park for her, the same one Johnny used. There was one entrance for both of them. So they were both secure. Neither one got special treatment other than Johnny got more attention by the sheriffs because the crowd was pushing to throw stuff in his car, gifts and whatnot, and trying to touch his hand or grab his hand. So they had to push people back for Johnny. She just came and went. In fact, I was the last day was out there. I was like, does Amber Heard go this way too? She goes, yeah, that's her car right there in front of you at the light.
Yeah.
And I'm like, I didn't even know it was her. Nobody cared. Nobody was booing her or yelling. They just completely ignored her. They could care less that she was there.
Nobody cared.
There was one crazed fan that was yelling at people over their Johnny Depp signs. Send her to Davy Jones's locker. She thought that was a death threat. She thought that was a death threat. But that's the only thing I saw against Amber Heard, other than Christina Taft going around with her crazy data poster that nobody could read anyway. But no, the media would have been all over it. And the only one they found was the Davy Locker one. Davy Jones Locker.
Which is, I mean, come on, you guys,
Court could use identification when you got there. Yeah, I think they scanned it. They looked at the card, and I don't think it ever crossed their mind to look at the birth dates. I don't think it crossed their mind.
I agree.
Thank you, Sunshine. I appreciate it. Elaine obviously made this a just assumption during trial because the identities are sealed, right? Well, she would have known. She wanted the identities to seal, maybe because she didn't want this to come out afterwards. I think it's more that she didn't want them doing interviews. I don't know. She wanted it sealed. When did she decide that? At the end, right?
It was like slightly before the end. I think it was
So
after the break.
It was after Amber's testimony. They knew they had an issue.
Yeah. Yes.
Yeah. They knew things were not going the way they wanted.
Yeah.
So it was well after voir dire.
Oh yeah.
We got a little Amber fan. Look, stop bullying Amber. Just stop. Oh. She didn't have to file the TR. She alerted to TMZ to get publicity. 100%. That's how everybody knew it was there, and the jury knew it when Morgan testified from TMZ. They knew that she set this up. Oh, they just know. They just knew she was lying. They deliberately missed this, hence why they compelled the court to protect identities.
Yeah, I agree.
What else? I don't think we have too many other questions. I'm going back to the end. Any questions we have left? Otherwise, I'm going to let Jax go and we're going to sign off. Do we get this one? Do you think that some of these recent allegations against fake jury and other BS is also to keep off Australia trial? Try to postpone that as well. I don't think it'll affect the Australia trial in any way. I thought the most recent article we read of Law and Crime was really interesting when you put it in perspective. They are very strict down there with the beer bug, really super strict. So I think they've had trouble with backlog trying to get through. I know you learn these words, you have to say certain things.
Corona.
But you have to be really, they were very strict about it, that they had massive backlog. So they're trying to catch up. And yes, they're going to have to use these other agencies, including the FBI, which was reported way a long time ago by Tug and other people that, you know, so I just think their hands are constrained by the fact that it's taking so long to get everything through. They're already saying if she does it, goes with this defamation trial, appeal, it could take 1 or 2 years. So that puts that in perspective.
It's going to take a long time.
Johnny found this with the UK one in 2018, and it took several years.
Yes.
Thank you, Secret Miss Squirrel. You're awesome. Please like, hit subscribe, help me out. I really appreciate it. Yeah. Any news on Adam? I don't know. Adam made a comment. They said, "Where are you at?" And he put up the Australia flag. Adam's a teaser. It could have meant he's working on the Australia case. It could mean a lot of things by Adam, but I would love to know what's going on there. But I think he's working hard to get this indictment through.
Let's hope so. God, that would be so helpful. You know, just this blast of she's being indicted for perjury. You know, you're in trouble for potentially having lied in the court.
Yeah. And I don't know what's going to come next. Okay, so they found this motion. No chance of it going through. It's going to get kicked. Right now, it's here to Judge Azcarate because she's the one who rules what the jury can and can't hear and understand. And the jury's the fact finder, but she's the one who still governs this case. She's going to kick it.
It'll be the same process that he went through in London, where he first had to appeal to Judge Nicol, and then he went to the higher.
Yeah, they didn't have to do this. They're just free. It's free to do this. I mean, they don't have to ask permission. This is one last ditch effort before they have to pay the money for the appeal. So the next one is going to be the appeal. Now, someone said they had to file formal notice that they're going to appeal. And I kind of feel like they've both done that. And Emily D. Baker said that earlier today, that by Johnny Depp filing the objections with the judgment, he basically has preserved his right to appeal.
Correct.
If he so chooses done.
Yeah.
Elaine did not file objections with the judgment. She has filed a filing notice of all those transcript hearings and that pathetic PowerPoint of her plea and bar. So it seems that she's filed some kind of notice. They're moving to an appeal. She verbally told Judge Azcarate, we are going to appeal. Ben said, I don't think we're going to do anything. But that does not mean he hasn't, by filing those objections, he most definitely has reserved the right to do that.
Yeah.
So that's where we go from there. Does she have to put up the bond? It's interesting. I'm hearing from a lot of people that because the judge said it in court, it seems because she was awarded against her that even if Johnny doesn't try to collect, she may still have to put up this full bond based on what Judge Azcarate said in that hearing. You want to appeal, you put up a bond for 10.3650 million plus 6%.
Right.
She made it very clear you have to put up this bond. She didn't say if Johnny doesn't want to collect. Oh, sorry, McCourt. I'm sitting here blabbing and it came through, so I was able to block them. No, but you're doing a great job. Keep up the good work there. I don't know if she's, so you think she has to have the money to appeal, or she's going to try it with the $500 and hope Johnny doesn't come after her?
I don't know. There's so much like confusion and different takes on this that I'm not really willing to say what I think, because it's not, I don't know. You know?
Yeah, I don't know. It's like, well, I guess we'll know July 24th. That's 30 days,
Yeah.
or July 23rd.
No.
The assault and glassing charges can still be filed in Australia. There's no time limitation there. That's my understanding. My question is, would Johnny have to instigate that or initiate that? And I'm not sure that he will. I mean,
I don't think that he's done. It's over for him. You know,
someone with money is backing her. I don't know. They're complaining that she has no money to do this appeal. She hung out in the Hamptons for quite a while. She's not rushing home.
Supposedly with Romero from the ACLU. So.
Well, here's what I found interesting that I didn't, and let me just put this blurb in here. And we were so busy with the trial, I didn't catch this. So on April 15th, there is a hearing, and Eve Barlow is booted out. She's out officially. And that's the Friday hearing date. What I found interesting that I didn't realize until later was that April 14th, Eve posted from her apartment in LA. So she was already gone out of, and we all assumed she was hanging back.
Shipped her ass out.
She was gone before the hearing. They were so angry at her.
Out of Australia. Get the fuck off.
They weren't angry over the tweeting. They were so angry that she embarrassed them by giving them a photo that was a year old, the IG post that she cropped, and they jumped on it, and she humiliated them, and they said, you get the fuck out of here. So April 14th, she's back in LA. She's still fighting for Amber, trying to get in her good graces maybe. Amber's done. What's she doing? She ain't hanging out with Eve. She's with her sister now. It seems to be her new best friend. I don't remember her hanging out so much with her sister in the Hamptons. And then the latest we saw, possibly she flew to Miami.
Yeah.
Did you see that post?
Yeah.
I thought it was strange by the way she was positioned. I didn't see any children or Whitney around her. Just
there's other pictures from inside the airport though, and she has the baby.
Oh, I didn't see those. Okay.
So there's a couple other ones. Yeah. Which is interesting because Brian and I just talked about how Amber was in Miami with Elon before she went to see Johnny in San Francisco.
Oh, that's right. But that was at a hotel, right? It wasn't something he owned. I know there was like bungalows.
They were at the Delano in South Beach. Yeah.
Yeah. And she was staying at some bungalow.
Yeah.
I don't remember. I was at the Delano. I didn't know they had bungalows. Whitney will always be Amber's punching bag. It's very scary.
Yes.
Yeah.
Yep.
She has to keep her sister quiet now. Do they pay better at KFC in the Hamptons? Well, she's moved on to Miami.
All right.
I hope Elon is not, but who knows? Well, Jax, thank you for coming on. I think we covered a lot.
You're welcome. Thanks for having me.
I don't think this motion's going anywhere. I definitely think the jury got it right. The jury absolutely got it right. And the best takeaway from this motion I got was Elaine saying they found the verdict, found that she lied. Not that she couldn't talk about it. The verdict found that she lied. And this is from her own lawyer statement.
Yeah.
So, it's time for me to go. Take care, everybody. I will
post
my outtake and See you guys, and I look forward to coming on with you guys.
Hell yeah. I like that everybody's got different channels now because like we all pop around and everyone kind of has their thing that they're doing and we can each like input on those niche you know what I mean? I like that.
Yeah, and I like the live. We don't have to edit it.
Yes, me too. Me too.
Oh, editing that stuff was so hard. I know. Researching it was hard, but you had to listen to it again.
Yeah, that was hard.
I do edit
It's all
my
right. We did it.
videos. I do edit my own.
It's easier.
Okay,
The
I'm gonna
video
go
you
now.
can see. All right.
Yep.
Bye.
All right, bye-bye.